Check, check, check. All right, I probably didn't have no volume. I'm sorry, I didn't put my volume through. I wasn't looking at my meters. All right, let me run that back again. I want to welcome everybody. I'm going to do another video review. And as I was saying, I've been all over the internet. I've been noticing more and more people are using this technique and finding out what's going on in the court system. And as I was saying, this technique goes back, you know, it go back a long way, like 2002. If you ever really study one man out, you'll see that was the technique homeboy used to get out of jail. You know, the whole point in all of this, and, you know, I'm really kind of ambivalent about some of the things I talk about because there are people who belong in jail, but they abusing the system. And, you know, it's just got to the point where it's abuse. I was in there, I saw it. It just looks like like a modern day slave camp. I think they would just do better just banning people out of the cities and sending them out into the country. That would be better than just sticking people in jail, but maybe they're afraid of that, I don't know. But, or giving them something to do or something like that. But this is the technique. This is the technique. Trying to find out the jurisdiction the court is operating under. I want to give a big up to everybody. What's going on? What's going on? What's going on? Let's get the likes up. Let's get the likes up. Get the likes up. Like, comment, and subscribe. We got another episode. Like I said, I got some other stuff that I want to review too. A couple of other videos I'm going to do a review on, but we're going to continue on the video from. It seemed to be very popular. A lot of people were watching it. But do y'all see? Let me tell y'all something. Do y'all see while I'm doing these videos? Because these are important for you to know. But do you see how many views I put up something? Just put TDA account on it. It already got 35,000 views. I just put TDA account on it. And this is like some of the stuff you should know, especially if you're going to be doing something like that. It's just, I don't understand people's thought process. Well, I guess I do. You know, I guess I do. I do. I don't know why I'm saying that. I understand. I understand everybody's thought process. I know exactly. Appreciate that, Ron Henderson, the 499, the 4 bones, bro. I appreciate that. Appreciate that. All right, well, let's get to it. You know, this is a continuation. I ain't gonna hold y'all up. Let's get to it.
June the 10th. Those dates fine,
Jury trial.
Yes, I got the jury trial. And June the 10th, you need to appear back for a final pretrial date on June the 10th at 8:30 a.m. Let's clear up this. What do I need to do? All right. So statutory provisions illustrating the use of court's contempt powers. Courts have inherent power to punish contempt of court. This power cannot be limited by statute, but the legislator may still provide for use of the contempt power in certain situations. The Michigan legislature has enacted numerous statutes providing for the use of the contempt power. The broadest of these statutes, Section 1701 of the revised judiciary.
Okay, you see how he's talking about statutes and he's talking about the legislature. And also notice the fact that the man has asked him what jurisdiction they're operating under. Now, he took the time to look up the Michigan statute as it relates to contempt, but you can't tell me what the jurisdiction that the court is operating under. I'm telling y'all, that's why you need to watch that Howard Freeman, the UCC connection. The reason I put so much time and effort in that video, the UCC connection, because Howard Freeman was telling you why they can't tell everybody everything. And that was a very intricate part of my research. It led me in the right direction. understanding the Erie versus Tompkins Railroad decision. Everything changed. Everything started to switch over from common law into this commercial type law that they started using. All right, in 1933, after 1933, I think it was 1935 or something like that. I forgot when the Erie versus Tompkins Railroad decision was, but you know what I'm saying. But these that video, you got to really watch that video and the discussion he's having in there, and when he's saying that, you know, these judges, you know, they can't say admiralty, so they call it statutory. They call it a statutory jurisdiction. They're not going to call it admiralty jurisdiction, and they know it's fucked up. They've all been instructed. That's why they all get uncomfortable. And then, yeah, people have the audacity, like attorneys who are watching me right now, they have the audacity, the unmitigated gall to come over to my channel and start talking about how crazy people are. When you can't answer this, when you're judges who you go before, they can't answer this single question, and you yourself, you wouldn't even have the nuts to go in there and ask to answer that question because you're like a slave to the courts. You're not going to do anything. Your first duty is to the courts. You're like their slave. You're not going to go in there and ask it. So we got to go in there and ask. And you come out here and y'all make these videos and things to try to persuade people or dissuade people from going in and trying to find out the truth about what's going on. What is really interesting about this entire thing is that, do you really think the truth is going to stay buried forever? The truth always wills out some kind of way. The truth is always going to come to the light. That's a Shakespeare. You know, Shakespeare said that the truth wills out. All right, so the truth is going to come out. It's going to rise to the top. Y'all don't understand that? There's a maximum law that says the only thing the truth fears is to be hidden. I just don't understand it, how you think you're going to be able to continue this. We're in the age of information. We have the internet now. Information is going all over the planet as fast as hell. You can try to suppress it all you want to, but it's not going to stop it because the creator of the balanced universe is going to make sure there are avenues for people to receive the truth. It said the whole world should know the truth, and then the end shall come. So so we got to know the truth about what is going on right here. And he's talking about contempt. Now, when you talk about admiralty, admiralty deals a lot with contempt. In the admiralty books, they call it contumacy or contumacious conduct. All right. They deal a lot with that in admiralty. That's another thing. That's another feature you will see a lot in admiralty is contempt. Right. So the question should be, is this going to be a civil or criminal contempt? All right. Because they have different time frames also associated with what kind of attempt. So right now he's reviewing the statutory code because he is a what? He is an administrator. He has a ministerial duty to perform. All right. So let me see if I can pull this up real quick so I can share it with y'all. Yep, here it is right here. Let me pull it up and put it on the screen for you. I thought... Oh, okay, here it is right here. I'm tripping. Chrome. There we go right there. All right, so this is a document that I created years ago. I might have to download this thing, man. Let me download this thing. All right, let me see if I can switch the window up. Is this yeah, there it is. All right. All right, so this right here, I'm learning how to use this program, y'all, so forgive me. This is a document that I created some time ago. I really like this program though. This thing is nice, man. This thing is nice. This thing is nice. All right, so right here, this is an outline of the Constitution. And what this document is, this is my research. I created this document. So I'm going to explain it to you because I don't know how many of y'all have seen it before. Let me see if can I blow it up some? I don't know, I think this is, okay, yeah. All right. All right, so this is the Constitution for the United States of America. Now, this is based off the premise that there are two constitutions. There's a Constitution for the United States of America, and there's a Constitution of the United States. There's a distinct difference between United States of America and United States. The first thing you have to understand that law is a science. All right, so all the words have specific meanings. So if they say United States of America and then they drop it off and just say United States, that has a specific meaning. Don't just think that they're just lazy. They just took of America off of. No, that is a proper noun. It is the name of a particular person, place, or thing. All right. So we're talking about the United States is like a corporation. Now, when you look up the definition of constitution, you can see the constitutions are used to form corporations as well. You'll find this under parliamentary law, which is legislative law, because we're dealing with the legislature. So now, under the Republican form of government, or what common law, in the organic constitution, we have three branches of government. We have the legislative branch, the executive branch, and the judicial branch of government. These three branches form checks and balances on each other. Okay, so what that means is that we set up our government where no one particular branch is the king. All right, so people always talk about the president. The president is the chief of the executive branch of government over the armed forces. He is not a king. But a lot of people like him to make him out to be a king. It just seems that way. I just think that that's a distraction that they have in the United States, because really the most powerful branch of government is the legislative branch of government. Everybody knows that because they can declare war. They make the laws. Hell, even if the president vetoes a law, they can come back with 2/3 of a vote and still pass it. Okay, so your legislative branch of government is the most powerful branch of government with your senators and your House of Representatives. Now, you can see right here under Article 1, Section 8, Clause 17, the legislature is authorized to create a separate entity called United States. United States Code Title 28, Section 3002-15 defines the United States as a corporation. This corporation has ultimate authority over all territories under its jurisdiction. They call that plenary power. All right, plenary power means they like God on the territory. So like Guam, Puerto Rico, American Samoa, Washington, D.C., can't nobody come in and tell them nothing. They all powerful in that jurisdiction. The Constitution doesn't even restrict their power. The Constitution doesn't even restrict their power in a territory. All right, so that's why they wanted to get you in a territorial jurisdiction, because that's how they usurp your authority as them being your public servants, and now you're kind of like serving them by making you through the principle of a novation. A novation is when you change debtors out. All right, so they got you responsible for the national debt, because the national debt is a federal debt. It didn't have anything to do with you. It's the debt of this corporation. They borrow monopoly money. They're borrowing monopoly money. So it can't be constitutional. So it has to be within their territory, because our government is the one printing the money. But why do we have somebody else printing our money? How are we borrowing from the Federal Reserve when the Treasury is the one supposed to be making the money? No one asked this question. No one ever asked this question. No one asked this question. They're not smart enough to ask this question. So the Federal Reserve is, so through these social security numbers, they have made us U.S. citizens. You know, anything U.S. District Court, U.S. Postal Service, U.S. taxpayer, U.S. person, U.S. citizen. All right, all that you hear, when you hear that term U.S. and it precedes whatever comes after it, that is their tag. That is their identification to let you know that it is legislative in nature, that it is under the authority of Congress, and it is within the territories. That's how you're going to know that. So now you have a federal United States. It's colorable as a corporation. Now, within this corporation, they also exercise, I'm not going to call them branches of government, but they exercise, because we're talking about the legislative branch, they exercise legislative, executive, and judicial powers. And what they do is, through the delegation of powers doctrine, they delegate a portion of their power to the other branches of government so they can come inside this corporation and do what needs to be done. So this is what you're seeing. It's very important for people to understand this, because this is the basis of the deception. The basis of the deception is to name things exactly the same so you can't distinguish between them. To have the court proceedings look all exactly the same so you can't distinguish between them. An administrative court proceeding looks just like a common law court proceeding. Everything looks exactly the same. So you're not going to be able, all the words have multiple meanings. It's just like when the Native Americans say pale face speak with forked tongue. What that means is, what means just a snake, it means that all your words have double meanings. You look in an English dictionary, all the words have double meanings. So almost all the words have a commercial meaning and a common law meaning. And usually that commercial meaning is like the third sense of the word. You'll notice that when you start getting into a Black's Law dictionary. So you see right here, all of this right here is how they set it up. So under this legislative branch of government, I drew a line down here, and this is the corporation down here. All this is the corporation exercising legislative power. This is your statutes, codes, rules, and regulations of Congress. Your executive power. These are your administrative agencies and the president. And then your judicial power. Okay, these are Article 1 courts. This is your court. These are not Article 3 courts. Up here you had Article 3 courts. Down here you have Article 1 courts. Now you could have an Article 3 judge sitting in an Article 1 court because of delegation of powers doctrine, just like when they have a judicial committee or something like that. An Article 3 judge you can find an Article 3 judge sitting in an Article 1 court, but he will not be exercising Article 3 powers. He's been delegated powers through the legislature to act as an administrator over those proceedings, which is good because what? The Article 3 judges are the defenders of the Constitution. So it'd be good to have an Article 3 judge sit in your court to make sure that all the procedures are followed to ensure there aren't any constitutional violations. I can understand that. But there's a lot more administrative judges than Article 3 judges. Now, you can get on the internet and y'all can, let me see if I can pull one up real quick, because I know we got some people in the legal profession that are watching, and they're not watching to see if I'm wrong. They're watching to see how much I know. I already know what it is. You're watching to see how much I know. So okay, so let's see. Article 1, delegation of powers. Let me see if I can find something. It's a Columbia Law Review. I might have to do this afterwards. Yeah, I think I'm gonna do this afterwards. I'm gonna have to look it up. But I want you to Google right now, delegation of powers doctrine, and I want you to read some law reviews. Maybe a Harvard, Princeton, Fordham Law Review, just something like that. You know, find some law reviews on Google and start reading so you'll understand that they understand this. That even some of the students in law school, they're questioning some of these things. Until they get out into the real world, they don't question it anymore. They understand what's going on and they don't question it anymore. But some of them have questioned this, and even all the way back when you read in the analysis and interpretation of the Constitution of the Supreme Court, they even questioned it back. The first Supreme Court justices were questioning it. Okay, how a judge gonna wear two hats? You'll probably, if you've been in this a long time, You probably heard them say the judge wears two hats. He wears an Article 1 hat and an Article 3 hat. An Article 1 hat is for a U.S. citizen. An Article 3 hat is for a private citizen of the Republic. There are not a lot of private citizens of the Republic. There's not a lot of them. So they spend the majority of their time reviewing Article 1 decisions to determine whether or not there were any constitutional violations. They only issue a certiorari, I think, on like 119 cases a year. Only 119 cases is all the Supreme Court hears. So this is something that you need to understand. If you're in prison and you're trying to get out of jail, the basis of all your legal research needs to be an understanding of what I'm displaying to you right here. Now, in this document, I also pulled out a lot of the definitions. These definitions all come out of a Black's Law 8th edition, so I wouldn't have to keep pulling it up. So right here, under the legislative power, we have statutes, codes, rules, and regulations. Once again, this is all under Article 1. So they have statutes. A statute is a law passed by a legislative body, specifically legislation enacted by any lawmaking body, including legislatures, administrative boards, and municipal courts. All right, look at that, administrative boards. The term act is interchangeable as a synonym. I try to tell people that. They always talk about this act and that act. An act is just a damn statute. This something act. An act is a statute, man. You don't know that? How much research have you conducted? It's something that's promulgated by the legislature. But they keep throwing this in my face as if it's some kind of law. It's a statute. An act is a statute. An act of Congress. So right here, the term act is interchangeable as a synonym. Do you know what a synonym means? For each of the sub-entries listed below, act is sometimes substituted for statute. Rule, a regulation governing a court or an agency's internal procedures. Contract, a promise or set of promises by a party to a transaction enforceable or otherwise recognizable at law. The writing expressing that promise or set off promises, all right? That's how you get it. Statute merchant. Now, the statute merchant that go back to like the 11th century or 13th century, where you could pledge your body for the repayment of a debt. So this goes back all the way almost 800 years. 800 years back to the statute merchant. Now, the statute merchant is one of two 13th century statutes establishing procedures to better secure and recover debts by, among other things, providing for a commercial bond. Now, if you're in the feds, I want you to pull out your paperwork or get your docket sheet and see if you can find the word commercial bond anywhere in your paperwork. That's going to confirm what they're talking about right here. I know it was in mine. Look in your paperwork, commercial bond. It establishes a commercial bond that, if not timely paid, resulted in swift execution of the lands, goods, and the body of the debtor. Black's Law Dictionary, 8th edition. So, if you didn't pay, they took your body. This was the beginning of the debtors' prisons. Now, they want to try to act like debtors' prisons don't exist anymore. But let's find out. Let's look at some expert commentary. It says, it is not a little remarkable that our common law knew no process whereby a man could pledge his body or liberty for the payment of a debt. Under Edward I, the tide turned. In the interest of commerce, a new form of security, the so-called statute merchant, was invented, which gave the creditor power to demand the seizure and imprisonment of his debtor's body. All right, so the history of English law before the time. Now, right here, you can see that they're giving you, what is that? What is that? I had to think of that. Because the Jews, when they came in, the Jews are the ones who came in with interest and liens, okay, because they couldn't own property in England. So how they got in the game, because they had a feudal type system and that kept everything secure. They disrupted the foundation of England, which is one of the reasons why they were removed. When they came in, everybody started borrowing money from them. They had money, but because they couldn't own property, what they used to do is loan out money and hold property as collateral. This is where I think where they come from. They say the bank can't own property because they never could. They wouldn't own the property, but had an interest in the property and they'd give it to someone else or something like that. They never were able to own the property, but they used it as collateral and put liens against it and things like that. This is your dead hand or your mortgage or or they call it the gauge, or the Jewish, I'm trying to think of the name. It's an article on the internet. I'll think of it in a minute, but it's really interesting. A lot of English law adopted a lot of the Jewish law. A lot of Jewish laws are all in English law. As a result, even after they removed them from England, they still retained all of their laws, and especially their commercial as it relates to commerce and things of that nature. All right, so it's just a bit of history for you to understand. And so this next definition is constitution. This is it right down here. Let me pull it up right here. This one right here. This comes out of Black's Law, 4th edition as well. Let me see if I can blow this up a little bit more. All right, so right here, this comes out of Black's Law, 8th edition. This is the 4th sense of the word parliamentary law. Parliamentary law is an English word for legislature. Over there, they call their legislature parliament. We call ours, legislative. All right, but it's all under the same principle. So parliamentary law, what is the meaning of constitution under parliamentary law? Under a deliberative assembly, a governing document adopted by an organization for its internal governance and its external dealings. All right, so it's for its internal governance. The Constitution really don't have anything to do with you unless you're a U.S. citizen and they pull you in and contract you in. It's just no different than a trust document. A trust document don't have anything to do with you until, like, let's say that you're a contractor and I need you to do some work. Well, when we do a contract, in that contract, I'm going to put a clause that for you to work for me, you got to agree to abide by the trust indenture agreement. Well, it's the same thing with you. When you become a U.S. citizen, you have to agree to abide by the trust indenture agreement. When originally the Constitution didn't have anything to do with you, it has something to do with them. It is the document that creates government and restrains government. It doesn't give you any rights because your rights came before the Constitution. The creator of the balanced universe gave you your rights. How can these motherfuckers give you rights? These motherfuckers didn't give you no rights. Y'all need to get that shit out of your mind. You don't have constitutional rights. You have constitutionally protected rights. You have fundamental rights. They give you civil rights and liberties, but your rights come from the creator of the balanced universe, not from your representatives who are supposed to be up there representing, protecting the interests of their constituency. Now, let's get deeper into it. It says the Constitution may be an organization's most authoritative governing document, but if the organization has also received a charter or adopted articles of incorporation or association, then the Constitution is subordinate to them. If the organization has also adopted bylaws, then the bylaws are subordinate to, and usually more easily amended than, the Constitution. The Constitution and bylaws are sometimes contained in a single document. So when you read this, you can understand, okay, so when we get back to this, what I'm saying, okay, yeah, it's the Constitution for the United States, the Organic Constitution of 1787, but they also created another Constitution for a corporation because constitutions are used to create corporations. And they made it substantially the same thing. It don't look any different. All right, so let's look at under the executive power. We got administrative law. What is administrative law? The law governing the organization and operation of administrative agencies, including executive and independent agencies, and the relations of administrative agencies with the legislature, the executive, the judiciary, and the public. Administrative law is divided into 3 parts, and establishing, 1, the statutes, endowing agencies with powers and establishing rules of a substantive law related to those powers. 2, the body of agency-made law, consisting of administrative rules, regulations, reports, opinions, containing findings of facts and orders. That's just like your regular court. When you get arrested by the feds, you're going into an administrative agency. If you're in the feds and you got a shot, okay, and you got to get taken before your counselor or your warden, they ask you who's going to represent you, and you say your counselor or somebody like that, you're going in an administrative agency. They use the same principle all throughout the feds. All throughout the feds, from the time you come into the courtroom to the time you're in the BOP. You ain't understanding this. The body, okay, so the legal principles governing the acts of public agents when those acts conflict with private rights. That's what administrative law is. It's governing over them when it contract. There's not now. When you look up administrative law in a American jurisprudence, which you should study, you can see that administrative law is there for the public. It is not to protect the private. All right. So governmental representation is an administrative capacity of any kind can be considered administrative agency. The president is an administrative agent whose enabling statute is the federal constitution. The 13 executive departments reporting to the president are administrative agencies. For example, the Department of Justice is a cabinet-level executive department, but it functions as the administrative agency that addresses the legal concerns of the U.S. government and its people. The department, its people, the U.S. government and its people is not talking about you. It's talking about federal. It's talking about in Washington, D.C. This is that language that they use to be throwing you off too. The department housed within the Department of Justice, such as the Drug Enforcement Administration and the Federal Bureau of Investigation, are also administrative agencies, and they have procedures and rules of their own. So this is all under the executive branch of government. They all receive a delegation of authority from the legislature, all of these, even though they're under the executive branch of government. They have the Department of State, Department of Treasury, Department of Defense, Department of Justice, FBI, Department of the Interior, Department of the Agriculture, Department of Commerce, Department of Labor, Department of Health and Human Services, Department of Housing and Urban Development, Department of Transportation, Department of Energy, Department of Education, Department of Veteran Affairs, Department of Homeland Security, United States Secret Service. When you deal with any of these people, the first thing they want to see is a damn social security number. Let's look at looks like now this is, once again, they exercise judicial power, but this is not under Article 3. This is under Article 1. They exercise judicial power because these are Article 1 courts. These are administrative courts. This is where you bring U.S. citizens into. Article 1 court. See, legislative court, under court. What is an Article 1 court? It's a legislative court. A type of federal legislative court that is not bound by the requirements of or protected under U.S. Constitution, Article 3, Section 2. Well, why is that? This is just a fancy way of saying the principle of separation of powers. Of course it's not. Because if we understand the principle of separation of powers, of course it's not protected under Article 3. They're two separate things. The judicial authority granted by the Constitution is with Article 3, not Article 1. But when you come into their house, just like when you come into my house, you come into my house, I'm outside my house, I'm just Yusef. But you come into my house, I'm the legislative, executive, and judicial. I'm the legislative. Children, you have to have your ass in the house at 10 o'clock. I'm the executive. I'm issuing out ass whoopings. I'm the judicial. Well, let me hear your story. Why are your grades so bad? Okay, well, you're grounded. You understand that? So when you come under their authority in their house, they have legislative, executive, and judicial powers in their house, but it's all under the legislative branch of government. It all comes under Congress. All right? And this is what we're trying to find out. This goes on the state and federal levels, by the way. All right? The same type of game is going on the state levels. So you have to ask them this question. Look, man, because the courts all look the same. An Article 1 court looks just like an Article 3 court. They have a clerk. They have somebody up there that they call a judge. They have a bailiff. They have attorneys in there. They have places where you can sit to come in. You file your paperwork the same way. Everything looks exactly the same. So how are you going to know the difference unless you ask? So right here it says, Congress has the power. This comes straight out of Black's Law Dictionary, 8th edition. Congress has the power, within certain limits, to create what are called Article 1 tribunals. This is under Article 1, Section 8, Clause 9 of the Constitution, in case you're wondering. These Article 1 tribunals are really akin to administrative agencies. Wait a minute, what? So you're saying that an Article 1 court, you're telling me that this Article 1 court is really an administrative agency, is really akin to administrative agencies? This is what I'm trying to tell you. When you get arrested by the DEA and they take you into court, what you are going in, excuse me, what, like the FBI, what they got up here, Department of Justice, Department of Defense, Department of Education, Homeland Security, all this. When you go in there, you're going into an agency court. That's why you don't see the judge that much, and that's why they also get you to plea out. You're an administrative agency. You're in an agency court. You're not in a judicial court. So right here, it's telling you right here, they're telling you this, all this right here. Congress also has the power within certain limits to create what are called Article I tribunals. These Article I tribunals are really akin to administrative agencies. That is, the judges do not have any constitutionally guaranteed lifetime tenure and protection from salary diminution. They always throw this shit to confuse you. Of course, motherfucker. We know that Article III judges are the only one that have lifetime tenure and protection of salary diminution because they have to be unbiased. So you couldn't give any power over the judges, over their tenure or their salary. That's why judges are appointed for a lifetime. So that's why they won't be biased. So nobody can come in and threaten them with taking their job or taking away their money or something like that because they have to be impartial, okay? Now, what they have done, they have clothed some Article I judges with these same features to try to hide it even more. So it's getting harder to detect unless you ask, okay? All right? So this right here ain't saying nothing. All you have to do is know separation of powers. You can understand that. They're not governed by the case or controversy limitation of Article III. Of course they're not. They're Article I courts. Why are you telling me all this redundant ass shit? At the present time, Article I courts include territorial courts, certain courts in the District of Columbia, courts martial, and legislative courts and administrative agencies that adjudicate public rights. Well, that was very vague. They didn't get very specific in that, but you can go on the internet and find that U.S. district courts are Article I courts. As a matter of fact, they had it on Justia or Wikipedia was talking about it. They had all of that on there. Somebody put it up and let you know they're Article I courts. But that's what we're trying to find out. We're trying to find out if this is an Article I court or Article III court. That's what we're doing because they don't have any authority under the legislature don't have no authority except to enforce the provisions of the powers that have been delegated to them under Article I, Section 8. So that's all their courts can adjudicate. They used to have what is called the Commerce Court and they had a tax court. But they got rid of that. They got rid of the Commerce Court and merged it with the U.S. District Court. So now you can't even tell. That's in there too. They merged the Commerce Court. Go study this if you don't believe me. The Commerce Court got merged with the U.S. District Court. I'll dig it up and find it because they tried to hide it. It was on the internet and I started looking for it. And then all of a sudden it got difficult to find. You know how they do. Commerce Court. Let me see if I can find it real quick. The district court continuing the merger should be shown to endanger competition in the lines of commerce. Let's see. Commerce Court, Federal Trade Commission. Let's see if I can find the United States versus the Interstate Commerce Commission. The Commerce Court only lasted about 3 or 4 years in the early 1900s. United States Commerce Court. Yeah, let me see if I can put it on the screen right here and read this to you. Because y'all got to understand all this stuff, man. To really understand what's going on, you got to do research. 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 All right, so right here you can see the Commerce Court. The Commerce Court of the United States was a brief-lived federal trial court. It was created by the Mans-Elkins Act, which Congress put together, 36 Stat 539 of June 18, 1910, and abolished a mere 3 years later by 38 Stat 288, effective December 31st, 1913. The Commerce Court was a specialized court given jurisdiction over cases arising from the orders of the Interstate Commerce Commission and empowered with judicial review of those orders. The Supreme Court of the United States was given appellate jurisdiction over the Commerce Court. That's why all they could do. They're just reviewing it to ensure their appeal, they just review the procedures. That's why the procedures were put in place. The Commerce Court also had one or more unusual structures in United States judicial history. There were 5 judges serving staggered 5-year terms on the Commerce Court. These judges were nonetheless Article III judges and were to be reassigned to an appellate court when their term on the Commerce Court expired. Moreover, even while they served on the Commerce Court, they also served as an at-large appellate judge and could be assigned by the Chief Justice of the United States to any appellate court to help relieve the workload. Remember, I told you, Article 3 judges will sit in an Article 1 court. Now, how does that happen? How's an Article 3 judge assigned to an Article 1 court? And we have separation of powers. That's because they're not operating in the capacity of an Article 3 judge. It says, the modern, it says, once the court was abolished, the 4 remaining judges of the court served out their lifetime appointment as an at-large appellate judge. The 5th judge of the court, Robert Woodrow Archibald, had been impeached and removed from office. The modern United States Court of Appeals for the Federal Circuit, created in 1932, has a purpose similar to the Commerce Court, although the Federal Circuit has a broader jurisdiction. Now, this is really interesting because it used to read, they would tell you that it was merged with the U.S. District Court. Let me see if they find it on Wikipedia. Commerce Court. I don't see it in here. But you just do your research because they took it down. They took that down. I mean, listen, y'all, I've been researching for a long time, and I think they watch me. You know, they must be watching me because I put up stuff all the time, but I guarantee you I'll find it for you and put it back up here. They merged, I'm saying this on video, they merged the Commerce Court with the U.S. District Court. They're trying to hide that fact from you. All right, let me go back to my outline of the Constitution real quick. All right, so once again, we're going to get back to our video, but right here, administrator. What's an administrator? A person who manages or heads a business, public office, or agency. Look at all these things, business, public office, or agency. Second sense, a person appointed by the court to manage the assets and liabilities of intestate decedent. And the restatement of property, the term administrator includes the term executor, unless specifically stated otherwise. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. That's what these judges are with these traffic tickets. They're municipal. These are municipalities. All right, courts in administering or enforcing statutes do not act judicially, but merely ministerially, okay? And here's the expert, this is Thompson versus Smith. There's the case law if you want to look it up. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentation, or rationale. Territorial law. Let me see if I didn't put ministerial on here. I thought I put ministerial on there. You can look it up. But it's territorial law, the law that applies to all persons within a given territory, regardless of their citizenship or nationality. That's what I tell you about their nationality don't mean anything. All right, when you come into the territory, if you're under this territory, dependency, a land or territory geographically distinct. I'm not going to get into all the rest of this, but y'all see what I'm saying. Now this right here, I put this together to kind of try to illustrate when I was doing my research, how all this stuff was mapped out. And it always starts with words. You got to start with the meaning of these words. You got to look up the definition of these words. Once you start understanding what is going on, that's why I say you got to understand delegation of powers doctrine. You got to understand separation of powers. All right, you got to understand, that's very important for you to understand separation of powers. Okay, to understand how they are not acting judicially. That's why they're hiding it, because they know they ain't judicial officers. That's why when you're asking them this question, they don't want to answer, because they know they're not really judicial officers. They are ministerial. A ministerial means without. What does ministerial mean? You look that word up, it's going to trip you out. Ministerial. You don't exercise nothing. You just do what you're told to do. It's like an employee. You have a ministerial duty to perform when you're an administrative officer. This is what they don't want y'all to understand. Because y'all go in there, the judge. The judge knows what kind of judge he's at. They all know what they are. They know what they're doing. And some of them do it and they love what they're doing. They don't care. Some of them feel guilty about it. You start throwing it in their face, they feel guilty about it. Some of them don't give a fuck. Some of them get mad and start threatening you and shit. Like, nigga, I'm gonna hold you in contempt. Lock your ass up. You sitting there trying to put me on blast? This is what they do, you know, when you try to bring this to them. I've not seen one time, I'll show you another one, somebody using this same thing. I ain't never seen in 20 years a judge answer this question. In 20 years. Oh, where'd I put the live at? Oh, there it is. All right, so let's go back.
Act contains provisions illustrative of the uses of the contempt power. The statute states the Supreme Court, circuit courts, and all other courts of record have power to punish by fine or imprisonment or both persons guilty of any neglect or violation of duty or misconduct in all of the following cases. And I'm just going to cite section A of this as why I'm holding you in contempt: disorderly, contemptuous, or insolent behavior committed during its sitting and in immediate view and presence and directly tending to interrupt its proceedings or impair respect due to its authority.
He's so shaken he can't even read the damn statute. It talk about persons with a duty. That right there letting you know that it's an employee. I'm listening to what he's saying. I don't know if y'all listening to it. He talking about persons. Person is another word that we got to research. We got to all go back to William Blackstone commentaries. All right, where they give and come on forward from this to understand this word person. The word person means persona. This in Rome, when they used to put mask over the face, that was a persona. So your persona is your mask. Your persona is not you. The persona is given rights and duties according to your station in society or what jurisdiction. You have a different persona operating in different capacities under different types of jurisdiction. In the public, you got a different persona than you do in the private. It's called a person. A person is an artificial entity. A person is a legal fiction. It's right out of the Black's Law Dictionary. So this is what we don't understand. When we see these all caps names on the caption of the pleading of these court documents, and we're asking you, well, why is our name in all capital letters? And I know that law is a science, that nothing is just done for happenstance or just to be done, just been in due course. This is just something, a habit, we just are doing it. No, it's a reason why my name is in all caps on the caption of the pleading. It's a reason why my name is in all caps on a driver's license. It's a reason my name is in all caps on all my utility bills. It's a reason my name is in all caps on my Social Security card. You gonna try to play me and act like it's not. Like we stupid. Like my intelligence, let me tell you something, my intelligence supersedes yours because you're not able to fool me with that bullshit. You can call me names all you want to, but you're not gonna be able to engage me in an intelligent discussion. Because all you can do is throw rocks and call names and come into under my videos talking shit, talking about sovereign citizen shit. That's all you can do. That shit ain't working. You know why? Because my channel growing 200 or 300 people a day. Because you know why? Because truth is like honey. It's like honey. People are drawn to it. And then you can hate it. You can all you want to. You can't stop it because the creator of the balanced universe is on your ass, nigga. Let's see what he's talking about.
Okay, so that's what we'll put down there. Disorderly and contemptuous behavior in sitting in immediate view, presence of everyone, and in directly intending to interrupt its proceedings or impair the respect due to its authority. It's going to be order that you report today by 5 p.m. to the Wayne County Jail. And I'm ordering that you do 30 days in the Wayne County Jail. You have a right to appeal.
Okay, this is when you start coming with, Your Honor, will your bond withstand the commercial liability that is being introduced into this courtroom today? Because if you're trying to lock me up for exercising my constitutionally protected right of trying to find out the nature and cause of the action, and you want to give me a contempt charge, this is when you start. This is the grounds for taking action, like with liens and things like that. You just got to do it the right way, all right? But this is the ground. This is when you take the grounds for doing it. Because what did he do? Is he being contemptuous? He's not being contemptuous. He's just simply asking a question. A question that, to his understanding, he has a right to know, and you refusing to answer. So he done went and talked to somebody, and they done told him lock his ass up. I told you what they want to do is they want to lock you up. Now, they got something called the belligerent claimant. Let me read that to you, because I had to read this myself. Because you're going to have to deal with this right now. When you're fighting for freedom, this is the type of shit you're going to go through. And this is why this is not for the weekend warrior. See, a lot of you people think you're going to go into court and there's magic words that you say, or you just put your name on a piece of paper and give somebody a bill of exchange and your mortgage goes away and your car note goes away. And niggas is mad at me and shit because I'm talking about TDA accounts and shit like that. But the thing about it is that's because I've been doing this a long time and I'm going to give you the real. Other people gonna sell you some shit. I'm gonna sell you some shit too, but I'm gonna keep it 100 with you. And I'm not gonna try to dig into your pockets all deep or anything like that. I'm gonna let you know what it is because I done seen all these gurus come and go. Over the same ones over and over, come with the same shit. Promising, let me tell you something. They ain't gonna let y'all get no remedy where everybody can copycat it and 1 million people go through the door and get their houses are free and clear and their cars free and clear. What the fuck is wrong with you? You think they're gonna do that? You really think they're gonna do that? You sitting here on these other channels watching this shit and you really believe that shit. And you wanna come over here and talk to me. I ain't got time for that shit. You believe that shit? You believe that? Let me tell you something. If you believe that, and I'm going to be transparent for a second. There are people in the space, I've heard them say this, is like, Yusef, why is you talking to them? These motherfuckers, you just sell them some shit. They ain't going to, it's like, this is how some of them talk and everything. Because they just see that people, they ain't trying to learn nothing. They ain't trying to read nothing. They ain't trying to do nothing, bro. Why you wasting your time? Ask me this. Why you doing this, man? I'll tell you why I'm doing it. Because my family got destroyed behind these lies. And I told you when I was in court, I said, y'all fucked with the wrong dude. You fucked with the wrong dude. It's just something burning in me. You fuck with the wrong dude. You do that, you start fucking with my children and my family and shit like that, man. It's just like, and then you arrested me, you did all kind of things, pulled guns on me. I done had guns pulled on me and all kind of stuff. Y'all just don't even know. I could have lost my life a couple of times doing this type of thing. Because y'all don't really know how they get down. This right here, you just looking at in the court what they show y'all in the public. When they get him behind them walls and things like that, it don't stop. They finna let them one of them officers know. They're gonna put you in some sort of bad area of the jail where it's gonna be very uncomfortable, where it's gonna be shit on the walls. They probably gonna give you something to wear. When they dress you out, it's gonna be too small, so you're gonna be uncomfortable. Or they're gonna take you into the crazy part of the jail where a whole bunch of insane motherfuckers are. They got all kind of tactics. They got all type of tactics y'all don't know nothing about. You ain't ready for it. Some of you ain't ready for this. You ain't ready to be in solitary confinement and do all that kind of stuff right there. A lot of y'all ain't ready. Y'all ain't built for this. I'm just telling you, giving you the 100. Somebody say Trump should ask this question. Trump already know. He didn't call them fake courts. He ain't worried about nothing. Trump already know. That's why they're attacking him right now, because they can't do nothing with him when he becomes the president because of separation of powers. They tried to do that when he was president. He told them to go to hell. He said, y'all fake ass courts. I'm the president of the United States. I don't have to answer no summons. You better get an impeachment together. And they did that. It still didn't work. Because to impeach, you got to have a constitutional violation. What was the fucking constitutional violation? You didn't ask this man to show you his taxes. All of us who do business and we know taxes, we already know that wasn't nothing but a move y'all was doing because the general population is completely ignorant when it comes to taxes. Well, Trump make $1 billion and he only pays $700 in taxes. I was mad the nigga paid $700. I said, why you pay $700? Why you get it down to zero? How'd he get $700 up out of you? But they don't know. He came for, damn, here are my taxes. Everything they done threw at this man ain't nothing stuck. Not one time. And you people still out there, y'all trying to, Trump. Y'all looking at Joe Biden. Let me tell you something. This man can't even spell his damn name. Trump was the only president we had. We wasn't in a war. We didn't go to war. His country didn't go to war. You must like your people coming back in body bags. I know you do, because anytime you comment on my channel, you're going to do it behind a fake motherfucking profile. Because you don't want me to look up your ass and see who the fuck you are. Because I'm going to research your ass to find out who the fuck you are. What your allegiance are and what your alliance is. And I guarantee you most of the time, you some sort of communist, Marxist, socialist sympathizer. That's what you are. And that's what y'all better fucking recognize. You better start understanding what communism is. You better start understanding what Marxism is. You see them throwing this around on the TV all the time, and you walking around oblivious, don't even know what the fuck it is. Democracy, this Democrat ain't nothing but a socialist party. It's dependency on government. They want you dependent on government. And they want to own everything. They say we're going to own everything. You're going to own nothing and you'll love it. They want all, Bill Gates buying up all the land and everything. They already preparing to do it. Y'all ain't paying attention. They trying to buy up everything, all the farmland. They don't want y'all owning nothing. Nothing. They don't want you to own nothing. They want wealthy elite and slaves. That's what the future is. That's where we head. Ain't going to be no middle class. All that stunting and flexing, buying bags, and motherfucking all this shit, you better be stacking up your paper and getting you some land to grow your, you should be working on getting a load of your title so you can motherfucking start growing some shit. It was just like in the days of Noah. People were partying, having sex. Right now, you see the relationships are disintegrating. Everybody, they trying to get men to accept women with high body counts, calling you insecure because you don't want no woman and then took 100 dicks and shit like that. They're getting all this stuff right here. All of it is to destroy the family, get everything disintegrated, and get you all nice and prepped up to be a good little slave. Ain't no community, ain't no family. You by yourself, you separated. You done lost all traditional values. You don't have no morality. You're a heathen. Heathens can be made into slaves. That's Leviticus 25:45, in case you're wondering. Doesn't matter if you don't believe in the Bible. The people who run everything do. Fuck your beliefs. You ain't running shit. Tell me what I don't believe in. Nigga, you don't own nothing. You ain't got no power. no land, no industry, no natural resources, and you out here talking shit about what you don't believe. Until the rain came and swept them all away, just like in the days of Noah. Man, let me tell you something. I used to be highly suspect of the Bible too, until I started, and like Matthew chapter 24 is Jesus Christ talking about the end of the world. The very first thing he tells you, he said, be sure that no one deceive you. Many shall come in my name and deceive many, saying I'm in Christ, and deceive many. That's the first thing he went in on, is on the people coming in his name. And he goes on and gives a long dissertation on what signs to look for. And a lot of people, they're trying to tell you, oh, the Bible is bullshit. And they're telling you the Bible is bullshit because if the Bible is bullshit, then how you going to know the signs? What else you going to turn to look for the signs of the end of the world if motherfuckers is telling you the Bible is some bullshit? And this is my way I gauge things. I'm sitting there reading it and seeing the shit happening. I'm like, God dang, it's happening. You don't think we in a modern day Sodom and Gomorrah? This is worse than Sodom and Gomorrah. They chopping off penises, people identifying as different sexes, men and women having sex with each. What are you talking about? You don't think you don't think we in a modern day Sodom and Gomorrah? You don't think history is repeating itself? Okay. All right, let's get back into this. I just had to do my little rant for a little while because it really does hurt my heart. You know, I was listening to Candace Owens today. Candace, if you're watching this, beautiful woman. Beautiful. Let me tell you something, man. I think this chick is like sent from down on high. Her intelligence, I ain't never seen a woman. Let me tell you something, man, about Candace Owens. I personally have never seen a woman. I've seen men, but I've never seen a woman with that cognitive ability, the way that she talks so precisely and articulates herself and her thought processes. She ain't on some fucking genius level. And she came from obscurity. She wasn't affiliated with nothing. Before Congress got her own damn involved in politics, she rose up through the ranks just from making a YouTube video. She made a YouTube video. She talking at colleges and everything. Can't nobody fuck with her. Because she understands, she know what Marxism and communism and socialism is. And she know the people who are in control of it. And black people who are ignorant, who are Democrat, they talk about, this lady gonna talk about a lot of black people don't like you. That's bullshit. That's bullshit. That's bullshit. I don't know where you getting that off on talking, thinking that a lot of black people, it's almost as many black Republicans now as Democrats. So y'all need to get off of that shit. People are leaving the Democratic Party in droves. We were never affiliated with the Democratic Party in the first place. The Democratic Party is the party of the Ku Klux Klan. All the people, how they putting people in prison, passed by Democrats. These drug laws and all this kind of stuff. The people oppressing you, they smile in your face and stab you in the back. It's called the great backstab. They smile in your face and stab you in the back. And the reason that they get in LGBTQ, because they don't subscribe to anything in the Bible, because they feel like the Bible is talking against their lifestyle. So they're not gonna gravitate toward anything, no type of Christian principles or nothing like that. They rather start engaging and talking about that Bible is some bullshit. That's what you're hearing. It's easy for me to make a determination of where somebody is just by asking them a few questions. We don't have to believe in that religious stuff like you do. You don't. But thank you for drawing the line in the sand so we know who's who. Because that's all we're doing right now. All right? As it says in the Bible, he says, you cannot sit on the view. If you're lukewarm, I will spew you out of my mouth. You're either all right or you're not right at all. So what side are you on? Right now, we're drawing the line in the sand. That's all you're looking at right now. The line being drawn in the sand. Pick a side. Pick your side. You can't sit on the fence. No, ain't no such thing. Let's keep going.
This order, and I gave you the dates that the next court hearing will be had for motions due, responses due, the jury trial date, and the final pretrial date. Sir, do you have any further questions?
I just want to make sure I can speak without being held in contempt or.
Yes, you may speak. I asked you, do you have any further questions, sir?
Thank you. Your Honor, I would just like to tell you, man to man, that it was not my intent to be in contempt. Has never been my goal. I try to do everything in accordance with the law. As you can see, I have filed documents. I filed motions. I've requested information from the court, all in a desperate effort to wrap my head around the proceedings and what's going on here today. And I'm sorry if I may have gotten frustrated and not being able to understand the nature and cause and action against me. But just again, that was not my intention. I look forward to handling this as amicably as possible. I think that the record will show, I think that the prosecutor will agree that there is no international contract to which I'm tied under statutory jurisdiction. And I would love to see it. I would love to see that evidence.
This is one of the good things why they're doing the video conferencing, because they can't even come in and arrest your ass. They can't come in and arrest. That's one of the drawbacks, I guess, that they got. They can't arrest you. But let's look at something real quick. All right, this is the belligerent claimant. Now, this right here was something I had to read and understand because it gives you some insight into how to assert your rights. And I'm gonna read this quote from the Bible for you too. It says, "The privilege against self-incrimination is neither accorded to passive resistant, nor to the person who is ignorant of his rights, nor to the one who is indifferent thereto. It is a fighting clause. Its benefits can only be retained by sustained combat." Somebody didn't quote it correctly. "It cannot be claimed by attorney or solicitor. It is valid only when insisted upon by a belligerent claimant in person." Let me see if I can find a better, I think I got one on Scribd right here. Yeah, this right here, there it is right here. It says, "The privilege against self-incrimination is neither accorded to the passive resistant, nor to the person who is ignorant of his rights, nor to the one who is indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat." And this is why you need to go and look up words. Because you see how this is why you always go and look up the case law, because these motherfuckers be copying shit, don't fucking copy the whole thing right. I can give you a million examples of this. See, I've been through all this, people putting fake citations of authority on the internet. You go read the case, that ain't even in there or anything like that. You got to watch when you post a citation of authority. You got to go and read that citation of authority and find that quote in there to be sure that it is authentic. I did that one time, just reposted something somebody posted, and somebody, they blasted me up like, man, that ain't even in that case. I read that case. And he was absolutely right. But that was the last time that shit happened. But what we're saying right now is that you might have to, let's look at something real quick. Let's look at Revelations. Revelations chapter 10. what was that? Revelations, what was it? Revelation 2. No, it was Revelations 2. I'm sorry, it wasn't Revelations 10. Revelations 2:10. All right, yeah, I'm going. So, fear none of those things which thou shalt suffer. Behold, the devil shall cast some of you into prison, that you may be tried. And you shall have tribulation 10 days. That's how many days they put you in contempt, 10 days. 10 days, be thou faithful unto death, and I shall give thee the crown of life. Now, this is where, when you do all of this, you have to have spiritual grounding. Because when these people test you, I've been through the test, okay? When they test you, they will take you to the brink of despair. They will try to test you to see if you will give up. This is why I am the way that I am. I don't try to offend other gurus or anything, but I do have a problem with somebody teaching something and they've never been to court, they've never been in jail or anything like that, but they're trying to teach something on those subjects. If you haven't been in jail or anything, you need to stay the fuck away from those subjects. Stick to discharging credit cards and houses and cars or something like that, but stay away from this subject right here. Because you're not really getting, and really you shouldn't be doing that, because if somebody get arrested for a car and get a felony, they need to know what I'm talking about right here. If somebody start charging you, I put all the cases on here that people get arrested for different things with negotiable instruments, trying to do all type of people. Somebody came on my thing, Winston Stroud. I read the Winston Stroud case. Matter of fact, let's look at Winston Stroud real quick. That's interesting. Winston Stroud, he was a guru. Let's see if I can pull it up. Winston Stroud indictment. And want me to download it right here, grand jury. This is a superseding indictment. No, that's a superseding. Winston Stroud, that's his pleading, United States versus Stroud. Is this it right here? That was when he's trying to reduce his sentence right there. That was in 2020. Prominent tax dodger, state of New Jersey, redemption movement. They used to have it on here. And the reason I wanted the 10 foil hats and powered wigs thought of pseudo law. They call it pseudo law. And that's all you're going to see on here is just a lot of negative stuff. But let me see if I find the case. No, that's not it right there either. That's not it. Okay, this might be it right here. Let's see if this is it. Winston Stroud indictment. Here's the indictment. All right, so here's the indictment. This is superseding. All right, so you see right here, this is what I want y'all to see in all y'all indictments. On October 3rd, 2011, when the District of Oregon and elsewhere, Winston Stroud, with the intent to defraud as a material matter, utilized interstate commerce, including the use of the mails to transmit, transport, ship. These are all commercial activities. Move, transfer, attempt, and cause the same through the United States. You were in their jurisdiction. A false and fictitious instrument appearing, representing, purporting, and contriving through material scheme and artifice to be an actual security and other financial instruments issued under the authority of the United States and an organization. So right here, when you go in here and you read this, you're going to see all these. This is their jurisdictional element right here. If you look at your drug case or something like that, look for that word in there, because that is what ties into Article 1, Section 8, Clause 3, which is the which is the Commerce Clause. That gives them, that letting you know you're in the Article 1 court. This is what letting you know right here, because that's what they got the authority on. They're taking you inside of their courts. And then denying won't tell you what jurisdiction they offer, and then locking your ass up. The only way you're going to stop it is if you got to be, all the people in the United States of America got to be educated. Y'all think y'all going to stop this and, just stop it just on an individual level? You're not stopping this on an individual level. I tried. You're not stopping it on an individual level. That's why I went to teaching. And I went to the public and started teaching people, because you got to get people educated. They got to know. I done been in jail. I see what these niggas in law libraries be studying. They be studying 20 years the wrong shit. They don't understand jurisdiction, the nature of the action. They doing habeas corpus, always getting denied. But all they're going to tell you is, that's some pseudo law. That's some bullshit. That's some bullshit. I remember an attorney told me that. I was sitting in his office. He had them law books right behind him. I said, go to your law book real quick. I took him to OCGA 1711-1. I said, okay, when you find me guilty of a criminal case, you put a lien on me, right? Let's look at that real quick. Let's look at this real quick. See, I know we got people looking, so that's why I got to do this. I got to do this. I got to do it. And you see this right here, imposition of cost of the prosecution on the defendant. The cost of a prosecution, except the fees of his own witness, shall not be demanded of a defendant until after trial and conviction. If convicted, judgment may be entered against the defendant for all costs accruing in the committing and trial courts and by any officer pending the prosecution. The judgment shall be a lien from the date of his arrest on all the property of the defendant. The clerk shall issue an execution on the judgment against the property. This is why we're doing a secured party process, for all you motherfuckers out there wondering. You're putting a priority perfected lien against your property before they do. Because first in line, first in time. A lien is the evidence of a debt. And evidence of a debt means that there's a creditor and debtor relationship. And how are y'all gonna be the motherfucking creditor and y'all $42 trillion in debt? You are bankrupt. You might want to see the book on this. Let me see if I can pull up the book. Let me see if I can put up the book. Here it is right here. So this is the difference in reading it on the internet and going in the law library. Anybody who's teaching you and ain't never been in a law library, they don't know what the fuck they're talking about. They just wasting your fucking time. If they don't know, they like to keep talking about statute. Somebody always in my comment section talking about a statute. Nigga, do not ask me about a statute if you ain't went into the law library and pulled the book off the motherfucking shelf and read that shit out the book and read every citation of authority under it and looked up the fucking cases and study it. Don't come and acting like you know what that's talking about until you see how these judges have applied that statute to facts that have appeared. So right here, you see that word may that was in there? All right, so this is how you find out what does this stuff mean? Well, here it is right here. Imposition of cost, this is what I just read right here. So you get down here, you start reading this. Judge has no discretion in the matter of tax and costs. While the word may ordinarily denotes permission and not command, the use of the word in the second sentence of this section cannot be construed to mean that the trial judge is vested with discretion in the matter of taxing cost. This is all taxing cost against the convicted defendant. There is no provision of law for the payment of the fees of the officers of the court when the judge in the judge's discretion fails to tax the cost against the convicted defendant. And it cannot be assumed that it was ever intended that the compensation of these officers should rest in the discretion of the judge, not this administrator. All right. Also, other stuff, got other stuff in here too. Look at some other stuff. Cost collectible by FIFA. This what Gene Keating in his research. A fafe is a Latin word which means you have cause to be done. This is a lien. Cost in the criminal prosecution or collectible of the defendant by the levy of a fafe at the termination of a prosecution if it finally results in the conviction of the defendant. This is why we put in the security party process, man. Why y'all talking about we doing some pseudo law and y'all sitting here writing your law books, you telling us you putting liens on people. And the only way you can put a lien on somebody in the public, you got to have that goddamn social security number. Now tell me I'm a damn lie.
But also, you know, we covered the fact that the city is the injured party or the plaintiff. And this would be an improper venue anyway, but I appreciate your advice on handling that and moving forward with motions. I will be doing that. But again, this thing of contempt, it's just, you know, as one man to another, trying to understand and stand on my constitutional rights and exercising them. And I feel today, as what's happened is my pursuit in doing that has somehow been converted into crime against me, which is a tragedy in, in anyone's eyes, So I cannot consent to moving.
Somebody talking about, are you surprised these biased Google? Why don't you put in there? I put the damn law book on the screen for you. I don't like using Google. Is some trash right now, but I put the law book on the screen for you. I went to the law library and photocopied it. I went to Emory University law library. They got a lot. If you're in Georgia, Emory University got some technology for your ass in their law library, and I photocopied a lot of stuff. I don't just go on Google. I got videos on my channel, me going in the law library. Nobody reads them. Nobody watches them.
For it because I still do not understand the nature and calls against me. And I will be communicating in writing, and maybe, someone can give that to me in writing. And we can go from there.
All right. And the court has heard all of what I respect the fact that you're trying to use the system and you're trying to operate by your understanding of the system. And the court is not trying to impair you in any type of way to present any claims that you may have. I continually refer you to the Michigan court rules, the Michigan Constitution. The United States Constitution.
He keep on talking about the Michigan court rules. Man, it's your job to tell this man what jurisdiction you operating under, man. He ain't asking for legal advice. He's telling you what jurisdiction. That's your duty. That's the Constitution. I'm not looking for anything under the rules of procedure for Michigan. I'm asking you, I'm quoting the Constitution for the United States of America. What jurisdiction is the court operating under? You just tell me for the record. He ain't gonna tell him. You rather lock him up. This is threat, duress, and coercion, what you're witnessing right now. This is threat, duress, and coercion. But he ain't answered the question. I don't care if you're an attorney. Tell me he don't have to. Yes, he does. You're not no damn kings over here. We the people. We're the sovereigns. You are public servants. Answer the question. What's wrong? You're not doing nothing wrong, according to you. Why you can't answer the question? And if you want to pull me on any show, this question got to be answered. They don't want to answer that. Just stay on this question. You might get locked up. They'll call you crazy. They call you names, but I guarantee you what? They ain't gonna never answer this question. And if you want to know why, go watch that Howard Freeman's The UCC Connection. Study that and let him. Howard Freeman was a beast. Howard Freeman, well, he has passed away. Rest in peace. Howard Freeman, if you see anything with his name on it, I got something else. I'm about to make a video off of his right now. He was on the same lane I was on. That man was very, very intelligent. He studied this to the day that he died. And there was a lot of other people in history. They were very intelligent. A lot of them have been locked up, or they've been or they passed away and things like that. But that man right there, Howard Freeman, he had a lot of good information. He understood what was going on. And if you listen to him, you're going to see he talk just like me. And I didn't learn from Howard Freeman. I did not learn from Howard Freeman. That's a book called Howard Griswold has a document called Paper Arrows, and you should read that. It's called Paper Arrows. Y'all got to read, man. You got to put this together. It takes time. If you didn't have me kind of showing y'all where to go, it'll take you years to learn this. Thank you for the donations. Gilad Israel, Stephen Perrier. I appreciate the bones, brother. I appreciate the donations. The Minus, I appreciate it. Kelly, appreciate it. 303833. Kelly, I appreciate it. Appreciate it. Who is this right here? Samuel Brown, appreciate you, bro. Appreciate all the donations. I appreciate the donations. Thank you so much. Appreciate you. All right, let's get back and let's see what this judge says, because he's trying to lock him up right now. You're trying to lock him up. Lock him up for what? He didn't threaten the court. He's asking you, okay, now this is why he has to be aware of the belligerent claimant, because sometimes they might lock you up. They might lock you up. And you got to still stand on your square. They're trying to shake you. And you need to see to what level they will go to, the desperation that they will go to. Now, you go on another channel and watch this same video, and it's an attorney doing it. They're going to be clowning them the whole time. Oh, look at him. He's asking this ridiculous stuff. He's crazy. Look at these foolish sovereign citizens making a mockery of someone who's coming into court trying to defend their rights and asserting the Constitution because they don't respect the Constitution. I appreciate that. Sean DeMarco, appreciate that. Now, I'm not related to Roy Jones Jr., bro. He just old. Like we both gained some weight. That song got bald heads. They will give you a lot of times, you will see how they establish jurisdiction sometimes in their paperwork, but you got to know what to be looking for. All this is commercial in nature. I can't even understand how anyone could even start to disbelieve that this is all about money. I don't think it's a single person on this live that believes that this is about truth, justice, and the American way. And you locking up somebody for a traffic violation, and he coming into court asking what jurisdiction you're operating off of, and you're going to put him in contempt. I told you, if you go in there and just straight up ask him, is this Article 1 or Article 3, they'll put you in contempt of court just asking that question. A lot of times. I appreciate the five bones, the geek surgeon. Peace to the gods. Appreciate the master teacher. I appreciate you, bro. I appreciate you. All right, let's look at what the man going to say. Let's see if you have any remorse or anything like that.
You want to find jurisdiction, you want to challenge jurisdiction, and I told you, if you want to challenge that, you're free to do that. The court is never going to impair anybody to challenge any of the allegations that are held that are brought against them. But there is a procedure, and whether you want to, you got to play by the rules, sir. And whether you accept the rules or not, that's not going to change the rules and the stuff that has been codified and the stuff that has been litigated and argued for over 2 centuries. The rules are not going to change for your position. Now, I asked you to continue, not say anything. I tried, and I appreciate the fact that you want to.
Now, on this point, you do have a point. This is why the abatement is so important, because you're doing an abatement because they're procedurally out of order. That's what an abatement is all about. It's making them go back and do the proper procedures we have to establish. This is what, Let me read this for y'all real quick. Let me read, and you have to read this stuff and understand what I'm talking about. Let me pull this up for you. Let me read this to you real quick. This is a very good, this is something very, very good, man. I mean, it was some intelligent people writing some stuff, man. I ain't gonna lie. And this one right here, this one right here was very, very intelligent. Let me see if I can. So you see right here, this abatement of common law. And listen what this man is telling y'all. Listen real closely, man. Listen to this. It says, there are many that believe that special appearances by paperwork, motions, etc., nullify a court's jurisdiction. Under emergency powers, this is false doctrine. There is no remedy in challenging a court's jurisdiction except by abating its process first. Abatements are not a challenge to a court's jurisdiction, merely a good faith attempt to correct errors in process. That's all you're doing, correcting errors in process. Clear up the errors, judge, and I'll appear. Special appearances fail when a judge knows what he is doing. Under martial rule, judges do whatever they want, whenever they want, so long as he or she does not alarm the public or disturb the peace. Jurisdiction is always granted to try jurisdictional questions, even if one goes to higher courts. Defendants grant jurisdiction without knowing it because they never challenge the process that creates the jurisdiction in the first place. Just going in there having a conversation with a judge gives jurisdiction because they can't see or hear you until you made an appearance. So if you having a conversation with them, you've already made an appearance. Process is perfected by appearance, special or otherwise. Also remember, the court is not the building, the judge, or anyone else. It is the paperwork. If the paperwork is defective, there is no court and it ceases to exist. The only way to overcome the war powers court is by the abatement. Traffic tickets are a pain for all of us. When using the abatement strategy, first send in the notice of abatement, memorandum of law, and denial of corporate existence. So you got to deny your corporation. That comes out of Louisiana. A researcher found in Louisiana under their criminal statutes that they have a right to presume you're a corporation unless you put in a denial of corporate existence. So that's why the affidavit of denial of corporate existence is in here. And you always have to provide the law yourself. You got to come in and provide the law. That's your responsibility. So you need a memorandum of law, and you got to give them a notice of abatement. To the clerk of court, that generally takes care of the annoying ticket. If you do not hear from him within 15 days, send in the default notice of the notary to the clerk. If you receive a summons, which has the proper signature of the judge and the court seal, send in a subpoena and discovery interrogatories. You're going to issue a subpoena ducis tecum. A subpoena ducis tecum is a subpoena for documents. Very powerful. I had an attorney one time ask me, man, how the fuck do you know that? Research subpoena ducis tecum. Understand what type of subpoena that is. Very powerful to put in your arsenal. All right, so you're going to subpoena documents. And you're going to issue some interrogatories, which are, some questions for them, to the prosecuting attorney and the court. You're challenging jurisdiction, and the opposing party must traverse your challenge, or the court cannot proceed. In most cases, they will never give you the documents you have requested or answer your questions. They don't. They don't, man. It's amazing to me. They don't give documents. They don't answer questions. They don't do shit. That's why I'm sitting here like, what are y'all talking about? They just call you crazy. Just don't want to answer nothing. Actions at law, actions in equity, and actions under the rule of necessity military. When it goes on. You're challenging jurisdiction, and the opposing party must traverse your challenge, or the court cannot proceed. In most cases, they will never give you the documents you have requested or answer your questions. If they do, you won. The people granted authority to the state legislature via the state constitutions to adjudicate only a few matters. Actions at law, actions in equity, and actions under the rule of necessity, military. Admiralty was remanded to the federal government, and the states are supposed to have no authority to legislate in this jurisdiction. Well, they do because it's colorable. They don't call it admiralty. They call it creditor and debtor law, all kind of things. You'll never see admiralty. The only way you'll know it's admiralty, you got to go study admiralty. And then when you study their statutes, you'll see it. But you can't see it unless you know what admiralty is. If you don't know what admiralty is, you don't know what you're looking at. There was a time when someone aggrieved of harm would file a tort at law. Moreover, the nature of the action governs the rules of the procedure. That's why we want to know the nature. The nature of the action governs the rule of procedure. This is why we're telling them, Your Honor, okay, I need to know the nature and cause of the action because the rules of procedure under a common law jurisdiction are different from the rules of procedure under a colorable admiralty jurisdiction. I need to know which two jurisdictions you're operating under so I can know the procedures. You're trying to give me a contempt of court, and you ain't even told me what jurisdiction you're operating under. I don't even know if you have jurisdiction over me. I don't even know if you can even have the power to issue a contempt. If you don't have jurisdiction over me, how you gonna put me in contempt? That's why you hit them with the question, is this civil or criminal? If it's civil, that means it's money. Is this a civil or criminal contempt, Your Honor? I need to know that. This is because the people must have access to a remedy at law if this type of action could give relief. If one were in the military, if one were under territorial martial law, the court was a military court. If there was a breach of international contract, the matter was federal and heard under admiralty. The state legislature cannot vest a court with authority that has not been delegated to it by the people via the Constitution of the state. That's why the first thing you read, you got to read the state constitution and see what the powers of your legislature are. How can you even be involved in this and never read your state or federal constitutions? It's beyond me, because everything begins and ends with that. Because that's how these people got their authority. Y'all talking about your delegation of authority. You ain't even read what their delegation of authority is. And when you read it, use an old dictionary from that time so you can understand what the words in it mean. The state legislature cannot vest a court with authority that has not been delegated to it by the people via the Constitution of the state. They cannot create a new nature of action out of thin air. Later on, when the constitutions of the several states were amended to recognize and administrate corporations, a separate court was established and the action was in the nature of administrative. Live people could not be brought into administrative courts, as the only matter at issue was a breach of corporate charter by an artificial person. Somewhere along the line, the announcement in the complaint of the nature of the action was lost. They used to announce it. Remember I told you they dissolved the commerce courts? The attorneys all got together and decided that it would be much simpler for them if there were only one form of action. And there's only one form of action, the civil action. So today there is no disclosure of the nature of the action unless one demands to know the nature and cause of the action by using a demand for a bill of particulars, which is what he should be using right here. He should file a bill of particulars. I've been quite successful with this procedure, even if states have that have decided that the demand for a bill of particulars is a discovery motion before the court. For example, in Pennsylvania, the demand for bill of particulars used to be before arraignment so that one had an opportunity to raise a meaningful defense against these elements, a personal jurisdiction and venue, to include territorial jurisdiction as well as the nature of the action that used to be a part of subject matter jurisdiction. Within the past couple of decades, they moved it into discovery, which is after arraignment, so the ability of one to challenge the jurisdiction and venue of the court was lost. And this is all procedural moves they've done to try to, so y'all, because, you know, the thing is that, man, there are so many U.S. citizens and there are so many people out there taking advantage of benefits and privileges on the government, they don't even feel a need to even tell y'all this anymore. This is because entering a plea accepts the jurisdiction. In this way, only subject matter jurisdiction was challengeable. If they say this is a matter at law, my defense against this jurisdiction is whether there is a live damage party. I do not ask if there is an equity jurisdiction because equity is not a criminal type of action, so that eliminates equity. If they say this is a matter in hustings, which is the true nature of actions of administrative law, a matter in hustings means a deliberative assembly. You're in some type of business meeting. My defense against this jurisdiction is that I am not an artificial person unless I'm a federal citizen, but that is quite another matter entirely, unless they can show from the records in the Secretary of State's office that I've chartered as such. If they say this is an admiralty matter, my defense against this jurisdiction is whether the offense was committed on federal territory of which the state has retained concurrent jurisdiction, although I have not found how the state exercises an admiralty jurisdiction in light of 28 U.S.C. 1333. If they say this is a military matter, my defense against this jurisdiction is that I am not a member of their military. I am, however, a member of the militia of one of the several states, but they do not operate as such anymore. The nation is not under martial law, or is it? Given the fact that there are currently 14 notices from the president of a declaration of national emergency published in the Federal Registry, we may very well be in a state of martial law. However, they are not going to admit the nature of the action. Do you see? And I'm showing you right here on the video. They're not going to admit it. I've never seen them admit it. They're not going to admit the nature of the action, as this will admit their want of jurisdiction on the record for all to see. So they move to dismiss the charges every time. Well, I wouldn't say every time. If you do everything correctly, they will. But that's the problem with a lot of people. They don't have a procedure they follow. They just go willy-nilly in and just do shit. That's why so many people lose. They just refuse to hunker down and study this and do everything the right way, step by step. It says, while I will never succeed in bringing down the current regime in this manner, at least other folks see what I'm doing, and some decide along the way that they want to learn this procedure. I contend that if only 10% of the people enforce their right to know the nature and cause of the, we just need to get 10%. Right now, you got less than 1% of people coming to these courts asking these questions. If we had 10% of the nature and cause of the accusation, that we could most certainly shut down the incessant stream of revenue being fleeced from the people by these administrative courts. As far as the compelling government interest doctrine, this is clearly a matter founded in law martial rule. The military authority is in the process of returning control to the civil authorities, but has not yet completed the process. And this is what you commit to memory right here. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them, Your Honor. I'm therefore unable to enter a plea to the charge until I've had an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption. The courts operate on silent judicial notice of presumption all the time. It is time for this to end. Generally, when you appear, the police officer is not there because he's been instructed to stay home that day. You simply move for a dismissal for lack of prosecution, as the prosecutor cannot testify to facts which he has no firsthand knowledge of. Be especially careful of the judge, his conduct. He's required by his oath to be an impartial trier of fact, not the assistant prosecutor, which they do that a lot. When they get it, you get in there and get with them, they start helping the prosecutor. You'll be in there the whole time talking to the judge. The prosecutor ain't opened his mouth one time. Ain't opened his mouth one time. Well, I got some more on this I want to read, but let's get back to the video.
I don't know what position you're really taking or where you're getting all this stuff from. And I asked you to put that stuff in motion. But when I asked you to please be quiet, please, I give you ample time to speak. I have not impaired your ability to put what's on the record, but you continually say the same thing over and over. And then when I ask you to please be quiet, and when I tell you that I'm going to hold you in contempt, if you're not quiet and you continually go over and over and disobey what the court is trying to say, then I have left with no other option to do what I've already done. So.
Okay, I take issue with this right here, because if you don't have jurisdiction over me, why do I have to follow your orders? If you don't have jurisdiction over me, why do I have to follow your orders? How you gonna put me in contempt and put me in jail and you ain't got jurisdiction over me? If you don't have subject matter jurisdiction or in personam jurisdiction, then any order you issue is void on its face. This is why when I challenge jurisdiction, you can't move forward until we address it. And you can challenge subject matter jurisdiction at any time during the course of the proceeding. So this is the conundrum we're dealing with, and this is why some of the people call these people corrupt. This is where they're getting these corrupt labels from, all right, from what you're witnessing right now. Now, granted, I don't know what paperwork he put in. A lot of these guys, I listen to what they say, they don't follow these scripts point by point. You know, I got another one I'm going to show you too, where somebody's using the same type of thing, but he actually wins. And I'm going to show you that he got it dismissed. And I'm going to show you what he did and show you the difference. But this right, he was actually in the courtroom. And I'm going to show you that next. But that's what, now this judge right here, you can tell he's an administrator. He don't know what he's doing. He's sitting there reading the statute and, you know, he's nervous. You can see he's visibly shaken. you know, from the whole thing. He know what he's doing.
You have an absolute right to an attorney. I gave you Mr. Very, 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 very good attorney. Now, whether you want to listen to his advice or not, you have him there at your disposal. Other than that, sir, I don't know what to do for you.
Okay.
So I'm ordering
I
you,
think-
I'm
yeah,
ordering you to report to the Wayne County Jail by 5 p.m. today.
It just happened so fast, sir. I mean, I think we.
Well,
and
maybe
there's
you
a
may learn
frustration
something
that
from
built
this.
up.
Maybe you may learn something from this, and that 30 days will give you an opportunity to go read and educate yourself on how this works. I got other people that are taking the same position as you, and I've afforded them the same exact opportunity as you have. And they did not do what you did today. They're holding fast on their position, and that's fine. I respect that. But I don't respect you interrupting me, and it seems that you really need an education on how this stuff works, and I'm gonna give you one today. Now, Mr. Berry, can you put your appearance on the record, please?
Yes, Your Honor. Elwood S. Berry Jr., P28880, on behalf of this defendant.
Now, do you want to speak with Mr. Berry in a breakout room, sir, or not?
No, with all due respect, Your Honor, yeah, I have the right to represent myself in my own person. And that is what I intend to do after having understood the nature and cause of the action against me.
Okay. Well, I've given you.
He's sticking to his guns, which is good, because this is the type of thing that you're gonna go through. Sometimes now the judge is correct, and it's certain. This is what he was trying to be polite. He got excited about a lot of things, and this is why you got to be real. You got to practice. One thing that radio taught me how to do was to let somebody speak, but then not interrupt when they talk. That's a skill that you got to develop in life. Don't give these people a reason. This is what staying in honor is all about. Don't dishonor the judge. If you read creditors and their bonds, it tells you this. Don't dishonor the judge. Don't dishonor the attorney. Don't dishonor the sheriff. Don't dishonor anyone. Conduct yourself in a way. Also, yes, there are papers that you are supposed to file. Like these abatement papers I got right here that I'm going to show you. So the judge, the judge does have a point in some of the things that he's saying. But I don't think contempt was just that necessary. I just think it's a tactic that's being used to try to, what I call, fatigue them into compliance. Because he's trying to give them 30 days. 30 days? But, the thing about it is this too. He does have a warrant for his arrest. So that's going to be another thing. He's going to get arrested. He have a warrant for his arrest. They're going to have to take care of that. Everything going to get taken care of. Sometimes, I'm going to say this to you, man. This to my people out there. If you got a warrant for your arrest or something like that, and you're trying to deal with something like that, sometimes it is better to go ahead and turn yourself in and take care of the warrant. Because that ducking and dodging and shit, and I'm gonna tell you why. Because you'll get a resolution to it. You get a reset. If it's not nothing that's gonna take your life away or something like that. Like these traffic tickets and all this kind of stuff right here, you don't need to be running from that. You don't need to be running from that. Go on and bite the bullet or do whatever. You got the warrant on you and everything. You try to fight it, do whatever you need to do. But once they get that warrant on you, they're going to try to be looking for you and try to put you in cuffs because you're in dishonor. All right? Get that shadow, that cloud from over your head. And then once they bring you into the courtroom, be ready to deal with them. Practice everything you need to say and then be ready to deal with them. Because if it's a traffic ticket or something like that, they can't keep you forever. They can't keep you forever on a misdemeanor, But you got to be prepared sometimes to sit in jail. One time, this is the thing we used to say back in the day, you're not a sovereign until you've been in front of a judge. We used to say that. Everybody used to say that. They don't say that nowadays. But you say, you talking about you're a sovereign. How you a sovereign? You ain't never been in front of a judge to try to stand up for yourself. and assert your rights and demonstrate that you're more than competent enough to handle your own commercial affairs. So you don't have to take that advice, but it's just I'm a little older. I've been through almost everything you can name. Just because I'm up here teaching you does not mean that everything that I have done it works. I done been arrested. I done had guns pulled on me. I done been held in jail. I done went through all of this stuff. This is why I'm telling you this. I'm giving you my experience right now. Because a lot of people they out here teaching they ain't got experience. They be selling you a fucking dream. I'm giving you the reality of the situation. Yes, all this is true, but that don't mean that they're gonna roll over and do it for you because they are scared of anarchy or somebody like Timothy McVeigh or something like that. All right. Gotta understand these things, all right? Gotta understand it. Let's keep going.
We've gone over all the natures and causes. We've gone over the maximum possible penalty for these offenses.
I'd wait till he got through talking and I'd issue an objection. Objection, Your Honor, we have not gone over the nature and cause of the action. You still haven't answered. For the record, you still have not answered my question on the nature of the action. You still haven't answered my question on the nature of the action. He's saying, well, I go and you can study the rules of procedure. The Minnesota rules of procedure tell you what the jurisdiction of the court is. You want me to go to rules of procedure or rules of court? Somebody look it up and see if it's in there. Go look it up.
I gave you an opportunity to speak with how and explain to you how the court hears your representations. You can choose to file those representations or not. But in the meantime, I'm going to order you now. I gave you the dates. I'm going to order you now to report to the Wayne County Jail by 5 p.m. today. Do those 30 days. All right.
I do not consent.
All right. Very well. If there's nothing further, sir, have a very good day. No.
Himself in court. I know that it's his intention to resolve these matters without any further court appearances or, Your Honor.
No. No, let's not do this. This is how it started to hurt. Have we had this discussion before? The court is trying to say, then I have left with no other option to do what I've already done. So you have an absolute right to an attorney. I gave you Mr. Very, 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 very good attorney. Now, whether you want to listen to his advice or not, you have him there at your disposal. Other than that, sir, I don't know what to do for you.
Okay.
So I'm ordering you,
ordering
you to report to the Wayne County Jail by 5 p.m. today.
It just happened so fast, sir. I mean, I think we.
Well, maybe you may learn something from this. Maybe you may learn something from this.
Acting in an unbiased way.
Representations. You can choose to file those representations or not. But in the meantime, I'm going to order you now. I gave you the dates. I'm going to order you now to report to the Wayne County Jail by 5 p.m. today. Do those 30 days. All right.
I do not consent.
All right. Very well. If there's nothing further, sir, have a very good day.
You too.
Okay, is this Mr. Lockhart? Jamil Lockhart? All right, Mr. Lockhart, have we had this discussion before?
Yeah, I'm here on behalf of the defendant Jamil Lockhart, and you're making a special appearance.
All right, well, you got to make your special appearance to the Wayne County Jail. I told you that the last time.
Yeah, so I filed a notice of removal for all of these cases because I don't believe that, this court is capable of acting in an unbiased way. But I mean, there's been no response from the city, but to this point. I mean, just the last court date we had, perjury was committed. I mean, you guys put on the record that I failed to appear. And I spoke to you.
You did fail to show up to the Wayne County Jail. You were ordered to do 30 days in the Wayne County Jail. You haven't showed up. You still haven't showed up. So you're still disobeying. Let's not do this. This is how it started the last time. You're still disobeying the court's order, and you have to do 30 days. You have to present yourself to the Wayne County Jail. You have a warrant out for your arrest. And before we go over this other stuff, you got to go. You have to go to the Wayne County Jail. All right.
Yeah.
Okay, sir. So
I said what
I can increase the time if you can take to
Your
not
Honor.
be compliant.
Your Honor, I apologize for interrupting the proceedings. May I have a breakout room with this litigant, please, and thank you.
I don't know if he wants to speak to a lawyer, but he can if he needs to. He has that right to do so. You want to speak to the lawyer, Mr. Lockhart, or no?
Yeah, sure.
Join the room, please. Who's on that 8547 C guard? Miss Harris, what's gonna go with Mr. Lockhart? So I don't know why he's still sitting here.
Well, Your
My
Honor,
man.
if the court will allow, we would like to attempt resolution of the matters that are on the docket. So I would ask if the court could stay the contempt proceedings and allow him to handle these matters.
No. It's been well over a year. No, he's gonna have to go turn himself in, and we'll.
They want to lock his ass up. I'm telling you, they get you in that jail. It's gonna be it's gonna be 10 times harder to do whatever it is that you're doing. It's gonna be 10 times hard. The only upside of jail is if you ain't got nothing else to lose. Like you ain't got no job, girl done left you. You know what I'm saying? Nothing waiting for you when you get out. You ain't got nothing to lose. You ain't got nothing. That's when you're gonna find out a lot of stuff too. When you ain't got nothing to lose. When you get in your mind, okay, look, we finna go. Me and you, we finna go at it. That's when you find, but a lot of people got too much to lose to go through all of this. That's why they don't find out a lot. They know you got something to lose. They'll lock you up, take you from your job, take you from your wife, take you from your children, take you just being in that, being in that cell. A lot of people can't handle that, especially people ain't never been locked up before. Oh man, you talking about somebody ain't never been in jail before? Oh my God.
We'll deal with it that way.
Your Honor, if the court could, just in the interest of justice and judicial economy, if he could resolve these matters, if he's still going to have to do the 30 days in Wayne County Jail, if at time of sentencing, it could all be wrapped up together just to not further delay his constitutional right to speedy trial?
He's delayed his rights. He's delayed his rights to a speedy trial.
And I do have a resolution, Your Honor.
No, I don't want to, I'm not even going to entertain it. That ship has sailed. We tried to give him that opportunity a long time ago. He kept being contemptuous in the court. He comes with these far out legal theories that he has that I quite frankly.
When they say stuff like this is when they start insulting these far out legal theories. It's a far out legal theory, but nigga, you still ain't answered the question, what jurisdiction you operating under? But you're going to start calling this name far out legal. They all do the same thing. That's fine. I will conditionally accept Your Honor's contention that my legal theories are far out upon proof of claim. Your Honor will demonstrate to this court on the record what jurisdiction you're operating under. I'll take that. You want to insult me? I'm one of the people, you know, you're right. I'm not an attorney. I'm not a lawyer, but I have a right. The Constitution for the United States of America protects me against you. That's what it's for. It's here to protect me against you. And I'm invoking that protection right now. And you're trying to circumvent it.
You know, don't know where he's coming from on that. No, I'm not gonna even entertain that with it.
And Your Honor, I completely understand the court's position. I completely understand if he still has to do the 30 days Wayne County Jail, but I think that he was potentially misguided, did not understand the finer points of the law, court rules, and courtroom behavior and procedure. So now that he has the assistance of counsel, which I'm not saying that he didn't have the assistance of counsel before, if the court would allow him.
We offered him counsel then. He denied the counsel. Go back and look at the video. It's got over 270-some-thousand views on it. And I told him that 30 days will give him an opportunity to read up on the law and so he can make it and understand how this.
You hear what he just said? This his video did have about 200-something thousand views on it. But do you understand? You think he's going to admit on a video the jurisdiction that they operating under, and it's 237,000 people going to look at it, or possibly 1 million people? You think he's going to admit that? I want y'all listening right now to exercise your common sense. All right, you think he's going to admit that for all y'all to hear? We can see he pissed off because it's a cornering technique. See, he got pressure on him. These questions they're cornering questions. And he don't like the way that the question is being framed because it puts you in a corner. And he's getting embarrassed, quite frankly. He pissed off. Lock his bitch ass up. Hey, mad.
Process goes. So go ahead to the Wayne County Jail. You can take they probably have some legal books there. And we'll hear these matters when you come out, sir.
Your Honor, is any of this on the record or no? Or did we not?
No, it's not on the record because I didn't call the cases. I'm going to continue on. That appears to.
Did you catch that? They're not on the record. It's being recorded, but it's not on the record. All right. Did y'all catch that? You know, that's one of the first things you ask, are we on the record? If the judge doesn't say court is in section, you in some sort of in-camera proceeding. If you know what in-camera means. Like you're in chambers or something like that. If you're not court is in section, if court ain't in section, you know, you like in an in-camera proceeding. She just asked this on the record. Because how he talking, that attorney just said something kind of, you know, because some attorneys will get at judges. And that was kind of what that attorney just said to him. Are we on the record? All this shit you talking, are we on the record? Because they'll talk a lot of shit off record. Hey, well, ain't none of this going to the appellate court. It ain't on the record. But I don't even understand how they operating in this era of video conferencing and stuff like this. I ain't even figured out how all this is going. This is some new stuff to me. I don't even know how all this right here goes. I can't even right tell y'all because this is all new right here. How they doing things right now.
To be Charles Gardner.
Yes.
Okay.
Yes.
Your Honor, am I allowed to go back in the breakout room to explain that to Mr. Lockhart? Because he seems to have had a change of heart if the court would allow him to at least.
Maybe he can go turn himself in and you can file an appeal. File something to get him heard before the court.
He can file a 2241. I want y'all to write this down. A 2241, that's a habeas corpus. It's a pretrial habeas corpus. It's a 2241. Let me see if I can get y'all and show y'all what it looked like. It's called a 2241. All right, this is a petition for writ of habeas corpus. So you need to know what all your habeas corpuses are. You got a 2241, you got a 2254, and you got a 2255. A 2255 is federal, a 2254 is state. You probably can use a state, but you use it after you get locked up. But right now you got a 2241. This is pre-trial. So it's 2241. Let's see if I can get it to pop up. I say petition for writ of habeas corpus. When should use this form? You should use this form if you're a federal prisoner and you wish to challenge the way that your sentence is being carried out. Wait a minute, is this not the, did I get the right one, 2241? Let me see. Is this petition for habeas corpus? Submitting documents required filing field. Did I get it backwards? Preparing for a petition, you should use this form where your sentence is being framed up your prisons. You are in federal, okay, here it is. You are in federal or state custody because of something other than a judgment of conviction. For example, you are a pretrial detention or awaiting extradition, or you're alleging that you're illegally detained in immigration custody or something like that. Anyway, it's a restraint on your constitutional rights if you ain't been convicted of anything yet. So that's what a 2241. If you've been convicted, it's a 2254 on the state level and a 2255 on the federal level. So this is something that you need to have in your back pocket, because right now, your constitutional rights are being violated. And that's what they're gonna look at the procedural elements of it. So you need the procedural elements because you have to exhaust all your administrative remedies. That's a lot of times what they're gonna want, that you exhaust all of those. But you gotta make sure that you understand that this is some sort of that it's some sort of pretrial type issue that you're dealing with. So 2241, and you can just listen to what he's saying and everything. And you can hear the attorney talking. Let's just keep listening and see what he's gonna say.
And they can zoom in from the Wayne County Jail and we'll resolve it that way. But until he turns himself in, he's got a warrant out for his arrest. He's had this warrant out for I don't know how long. I can look back into the record, but and he's never presented himself. So he was contemptuous then. He continues to not follow or obey the court's orders. So he has to go through the time, or hire himself a lawyer to get it back in front of the court. But until we get the first matter resolved that we had, we're not going to get into the other matters.
The contempt proceedings arise out of his appearance in court. So he's still not allowed to just resolve these before he commits himself to the Wayne County Jail?
No.
Okay, Mr. Lockhart, join the breakout room.
All right. And that'll conclude it. I still see Mr. Lockhart here.
What y'all think that attorney thinking? I don't know, because she looking like this some bullshit. That's what it seemed like to me. I don't know. Look how she looking at the whole thing. Interesting.
I don't know what else to do. What else you can do for him, Mrs. Harris?
So, Your Honor,
She continues to disobey the court order. Just continues to do so.
Your Honor, I dare not say. I don't know. I don't think that it's an intentional. Oh, I can't say that.
Wait a minute.
I don't think. I'm gonna take that back. I'm gonna take that back. I think he has good intentions. I think he now has a better understanding of everything that is taking place.
I don't think so, because he came in here talking about he's appearing on behalf of the person Jameer Lockhart. So I think he's on the same path as he was that got him into.
Okay, this is something that has to be addressed, because this is going to be something, this is going to be the first red flag that they're going to have when you come into court and y'all start talking about I'm on behalf of something. I don't even do that. You know, I just say I'm the holder in due course. Here's a third party intervener making a special appearance as an authorized representative for the defendant. If they want to get into this is your name, I say, yeah, this is, I say, yeah, spell my name, capital J, lowercase o, lowercase h, lowercase n. And it's another guy, this next guy that we're going to look at, he kind of did that. You know, don't make too much of that things. And I'm here on behalf of the all caps person and all that. Leave all that shit alone, man. You ain't doing nothing but alerting the public and putting them in a space where they finna start treating you like you a sovereign citizen. You don't even have to do that to challenge jurisdiction. You know, he's like, hey, look, man, I'm here to know the nature and cause of the action. All right, you challenging jurisdiction right there. You don't need to do all that other shit. You know what I'm saying? Put it on your paperwork. What I put on my paperwork is I say, now comes, I put my all caps name bind through the undersigned authorized representative. Learn to do things in a way, get this in your mind, alerting the public. They get mad when other people is watching this shit, everybody looking at it. They're gonna try to clown you. They're gonna do everything they can to try to make you look like you crazy. And when you get in, the object of the game is a win-win situation, not a win-lose situation. When you go into win-lose situations, you're creating friction. That's what it tells you in Matthew 5:25. Agree with your adversary while you're on the way to court. At least your adversary hand you over to the judge hand you over to the bailiff, and the bailiff hand you over to the throw you into prison. I tell you, won't come out until you pay the very last penny. The thing about it is this: I don't like challenging jurisdiction right off the bat, but it is something that you can do. But this is the reason why, because you go through all this. You're going to have some kind of issues, whatever you do, but, you know, this can happen right here. But I don't think some of that is necessary. However, we're going to look at a person after this, all right?
The situation.
And Your Honor, we've had that discussion at length in the breakout room. He understands what it would take to resolve his matters. He understands how he has to represent himself in court. And so I think he's in a position that he wants to resolve these matters. We've had the discussion. We asked for leniency and mercy from the court. I understand if the condition is that he still has to do 30 days in the Wayne County Jail, although we would ask if the court would reconsider that sentence now that he has taken the time to actually listen to advice of counsel and be made fully aware of how he should present himself in court. I know that it's his intention to resolve these matters without any further court appearances or draining any further resources or delaying the process anymore. And I know that the court doesn't want to delay the process any further. I understand his behavior is what put us in this position as of right now, but we're just hoping to resolve today if the court will allow.
I'm not moving. I gave him ample, this is a 27 plus, maybe 30 plus minute video. I gave him ample opportunity. You know, and I'm not moving.
I mean, Your Honor, I mean, in that video, I did apologize to you for, I guess.
You apologize after you got the 30 days. I'm not moving.
I apologize after the offense was, I mean, I don't know what else I would apologize.
You and you still haven't showed up, and it's been over a year. And now you want me to have some sympathy for you and to resolve the matters. I have no sympathy for you at all.
Mhm.
I tried to discuss, we tried to have give you a fair opportunity to be heard. You keep spewing these legal theories that I've never heard of before. And, I've given you an opportunity at that date to speak with the lawyer. You refused that. You refused all the opportunities I've given you. And you came in here another time, a couple of months ago, and I told you we weren't gonna hear it then. You gotta go report to the Wayne County Jail.
Mhm.
So
I mean,
you've
so
had ample,
you'd have me,
opportunity.
you'd have me go to jail.
No, on behalf of Jamil Lockhart, I do understand that, and I know the court he may hear this often, but he does have a family that he supports. It would be a great hardship on his family, his resources, and his sense of economy in terms of his job if he would have to submit himself to 30 days in the Wayne County Jail. I understand that the court is not inclined to change that.
I didn't just give him the 30 days on the, he should have thought about that when I was asking him. I let him speak when I was asking him to not try to overtalk.
Okay, he throwing himself on the mercy of the court, but I ain't gonna lie. Depending on me, I probably would ask him, I'm sorry, Your Honor, will your bond withstand the commercial liability that is being introduced into this courtroom today? This is why when you come into the courtroom, the first thing you do is you ask him to state his name for the record. Because when you get a stenographic record of the proceeding, everywhere in the copy of the court case is just gonna say the court. It's not gonna have his name. But that's why you want him to state his name. Okay, and you can also stop by the Secretary of State's office and get a copy of his oath of office and bond. Okay. Because all this right here that he's doing, I understand why he's upset, but I don't think it's warranted. Not like that. Not to be trying to get this man 30 days for contempt. He got a warrant out for his arrest. So it could be, that warrant, I don't know what the warrant is for, or whatever, but none of his charges were that serious. It wasn't just, traffic tickets and things like that, which I don't think a lot of people should be going to jail for any fucking way, But it's coercive. That's how you know it's debtors too. They putting you in jail for money when they're not supposed to. They say they're not. But that's one thing you could say. Your Honor, will your bond withstand the commercial liability that's being introduced into this courtroom today? Because the thing about it is, sir, I asked you a simple question. I only wanted to know the nature of the action. That is my constitutionally protected right to know. Is that not correct, sir? Well, I told you to go get the rules of court. I mean, what are you talking about? Somebody just posted in the comments section. They said they didn't see it in there. They didn't see it. Did you see it? Did anybody look up their rules and see if it talk about the jurisdiction of the court? Anybody look that up? Somebody look it up and tell me what the jurisdiction of the court is. What he telling them to do? Yeah, let's get the likes up. What are the likes at? We likes at 3. Come on, let's get the likes up to 400. I'm going to be pissed a lot of people off with this video, y'all. There's going to be some people pissed off. Let's get the likes up to 400. Y'all do that for me. Get the likes up to 400. 400 once, 400 twice, 400. Some donations would be nice too. Some $1.99s and some $4.99s and some $9.99s and some 777s and some 1999s and some, it'd be nice. Let's get the likes up. Get the likes up. Let's get the likes up. Likes. 400. Let's get to 400. 400 once, 400 twice, 400, 444, 358. 358. We had 358. Let's get it up. 400. We're going to 400. 369. We had 369. Let's get at 400. 400. That should be easy to do. It's 467 people on there. Damn. There's 460-something people on there. I'm putting 67 people off the hook. 382. We had 382. 18 more people. 18 more people. 382, 382. What we got? 400, 390, 10 more people, 10 more people, 10 more people. Thank you, Mateo Veliz. Thank you for the 10 bones, bruh. 393. We had 393. Keep going, keep going, keep going. 7 more people. 401. Okay, we good. Let's get back. Thank you. That wasn't too hard, was it? I got to do this. It's a shame I got to do that, boy. It's a shame. Let's keep listening. I appreciate that Island Walker Hick, that 199. Is there some more trustee training coming? Yes, it is, a lot. Y'all think I ain't finna start classes back, but I am. I've been trying to get my health together and everything, you know. I try and lose weight, you know, diet, exercise. Let's go.
Court, let me give an opportunity to speak. He continued to disobey that. He should have thought about that then. There's a whole lot of people up in the penitentiary that have families that they take care of, and he's not going to the penitentiary. It's just county jail. So I'm just not moved.
Would this court consider amending it in such a way that he could only do weekends to complete his 30 days?
Yeah, but he hasn't even come to done anything. I'm not inclined to do anything for Mr. Jameer Lockhart or the person of Jameer Lockhart or whatever he wants to be called or however he wants to be described himself. Jameel Lockhart.
So yeah, he has the matters that are set on the docket for today. He has presented himself to the court today.
Okay, you want to take off? We'll take off the warrant. We'll give him a pre-trial date, and then he can go do his 30 days, and he can tell the sheriff in there that what his next court date is, and they can, or somebody can rid him out then. City of Detroit versus Jameel Amir Lockhart, case numbers SP 1247989, counts 1, 2, and 3. State of Michigan. Now the laws just don't apply to him.
This is something I get sick of too. They talking about the laws don't apply to you. No one ever said the laws don't apply to you. We're trying to make a determination of that, okay? And to establish that fact, we need to know what jurisdiction you're operating under. Ain't nobody say don't no laws apply. There's no such thing as nobody being under any law. You got God's law, you got natural law, you have positive law. Everything in creation is subject to some sort of law. Okay, what we're trying to determine is what kind of law are you saying I'm subject to? Okay, that's all. We're just asking you the jurisdiction. Answer the question. He going in all this trying to see how he done took this and look how he done twisted this around and made it look like he the problem. This is why I started my school. I've been watching videos like this for a long time. It is a ton of them up on YouTube. I urge you to go watch them. Watch many as you can. Watch as many as you can. Because I'm going to keep doing these reviews. I'm going to keep on reviewing them. Watch as many as you can. Because it's a ton of them. They putting them up. These attorneys, they making money. They don't even have to go practice no more. Because they got YouTube videos making a mockery of people and they getting like bread. Them attorneys making some money off them videos. A couple of them attorneys got channels, they making some bread. They making some bread to the point, I'm wondering if they even have to practice. I'm telling y'all what it is now.
State of Michigan versus Jamil Amir Lockhart, case number SX 378-29611. Appearance for the record, please.
Sharika Harris, on behalf of Jamil Lockhart, sir, could you state the name of the person that you are representing on the record, please, or that you identify, please?
So my name is Jamil Lockhart.
For purposes of arraignment, Your Honor, my client would stand mute, but we would ask if the court could read the charges, please and thank you, so that Mr. Lockhart is aware of what he is charged with and the nature of the charges.
What's also called SP 121-8072, counts 1 and counts 2 into the record as well. The SP 121-8071, that's a license improper. License improper, that's a maximum possible penalties, 93 days in jail and or $500 in fines. Count 2 of that is a no insurance misdemeanor, maximum possible penalty, 93 days in jail and or $500 in fines. SP 1247989, counts 1, unregistered, untitled, maximum possible penalty, 93 days in jail and or $500 in fines. SP count 2 of that is an improper license, maximum possible penalty, 93 days in jail and or $500 in fines. Count 3 of that is a no insurance, maximum possible penalty, 93 days in jail and or $500 in fine. And SX 378-29611, that's an improper license, maximum possible penalty, 93 days in jail and or $500 in fines. He's got an expired plate that's in default that I'm not going to set aside. He owes $174 on that. As for purposes of arraignment counsel.
Again, Your Honor, Jamil Lockhart would stand mute. Ask that the court would enter a not guilty plea at this time on his behalf. Mr. Lockhart, I hope you're recalling these are all things that we discussed in the breakout room. I told you how the process works.
All right. First of all, I want to bring your attention. Y'all see how this is all about money? This is all about money. It's all a tax. This is all a tax. It's all about money. Everything they're talking about is about money. I got another video. Y'all watch this video on YouTube. It's called the Judges Slush Fund. Judges Slush Fund. I might upload it on my channel so y'all can watch it. Because somebody did a Freedom of Information Act request on these courts and found out these courts are privately owned, and they're privately owned trading companies. They're making money. Really interesting.
All right, I'll enter a not guilty plea on his behalf. I'll give him a $0 bond. We'll set a pretrial in the matter for 9/22/2023 at 8:30 a.m. All right.
Yeah, there is
Still-
currently a recommendation if the court would allow a plea.
No. He's gonna have to go do the time.
So, sir, as we discussed, I think you would be better suited if you, 1, hire an attorney, 2, go to the Wayne County Jail and submit yourself so that your matters could be resolved. I understand that when you
Last
appear in
time,
court, there's
I
different
checked.
attorneys.
He didn't want an attorney. And I guess you have gotten through to him a little bit. He changed it. He came in.
Okay, as you can see now, I want y'all to pay attention to something. We didn't got all the way away from asking about the nature of the action. See how you brought an attorney, how you brought an attorney in. When you bring an attorney in, it's going to take it totally somewhere else. It's a wrap when you bring the attorney in because they're officer of the court and their first duty is to the court. I don't care who they are, how well they talk to you, how nice they talk to you in the back room, how cool they are with you, how comfortable they make you feel. In the end, you're gonna end up paying some money or doing some time in jail. That's usually how it goes when you enter an attorney in. He would have been better off sticking to the gut. The judge wasn't giving him nothing. You had nothing to lose. Okay, you're gonna put me in contempt and all of this kind of stuff. Well, I still want to know the nature and cause of the action. I want to know the nature of the action, sir. You haven't answered the question. He still ain't got an answer to that question is the point I want to bring y'all's attention back. He still ain't got an answer to that question. They trying to lock him up, giving an attorney. They pulling him into their process. He get pulled all the way into their process. Now, y'all need to study stuff like this. This is the type of shit y'all study. And you got to be like, okay, how did they pull off that magic trick? They used intimidation, threat, duress, and coercion. Threat, duress, and coercion. That's a weapon of choice to get you to do what they want you to do. And still ain't answered. If you're an attorney out there looking, you still ain't answered the question. You still ain't answered the question. Question still, I don't give a fuck what you talking about. The question still ain't got answered. What is the nature of the action? It is either there's only a couple. Common law, we know it's not that. Equity, we know it's like that because you said it's criminal. Admiralty maritime, that's it, it's one of those. That's why you don't want to answer it. Because we know it's not common law. We know it's not equity. That leaves admiralty. But we know y'all don't call it admiralty anymore. You call it a statutory jurisdiction. Now, everybody go to the law library and ask, where are the rules of criminal procedure for a statutory jurisdiction? Y'all, I'd be more than happy to find that. He ain't looking for legal advice. They say, well, I give you an attorney. Your Honor, I'm not looking for legal advice. What I'm trying to find out is your legal intent. Now, the Constitution for the United States of America, sir, grants me the right to know the nature of any action that I'm involved in, and it grants you the duty to inform me of that. Now, I don't think you'd be violating your oath of office, sir, by revealing that information to me. So would you please, for the record, state under which two of these jurisdictions you're trying this criminal action? Because in order for me to mount an effective defense, I need to know the nature of the action, sir. How can I win and you ain't telling me? I don't know what rules to look for because you ain't telling me what is the nature. The nature of the action determines the procedural rules. But pay attention. We done got pulled all the way into something else. We sitting here watching him get nailed to the cross now. He pissed off. His whole demeanor done changed. Judge is mad. Because he don't want to answer that question. All this is just a cover. They don't want to answer that question. Stay on that point. Stay on that point. That's the main point y'all need to understand. The Sixth Amendment and the nature and cause of the action. I don't care if you discharging debt or whatever it is that you're going to do. You ain't going to never find them answer that question. So if you going in there with that defense, I want you to pay attention to that right there because they ain't going to never answer that question. And once again, go watch the UCC Connection with Howard Freeman and allow him to explain. I did a video for it. I did an all-out video for it, put music with it, narrated it, and everything. Because I did that because that's how important that information was in the UCC Connection. That was a major piece of the puzzle. He say he got it from a judge. The man say he talked to a judge. This is about money.
Here, hearing on behalf of the person, Jameer Lockhart. And then when he asked him to state his name, he came and he indicated that he was Jameer Lockhart now. So I don't know what he like I say.
I mean, if I could speak a little bit here. All right, Your Honor, I'm not a criminal. I just want to handle this, get this over with.
I didn't say you were a criminal, sir. I didn't listen.
I know you didn't.
I didn't say you were a criminal. As it stands now, these are allegations. So until there's an adjudication of either guilt or not guilt, that'll determine, whether you're a criminal or not. So I don't know. You got these allegations out here. So I didn't make that comment. You were a criminal.
Right, right. No, I'm not saying that you did. But I just want to handle this and, put this to rest. At this point, I feel like it's taken up too much of my time, too much of, your time, I'm sure. And,
No, this is what I do every day, sir. I serve the city residents of the city of Detroit and the state of Michigan and whoever comes in here. So it doesn't take up my time. This is what we do.
Yeah. So yeah, and continuing, I would just like to, get this over with, pay whatever fines need to be paid. I would like to have my license back. I can't rent a car when I travel. I would like to be able to do that. So whatever I owe for these civil offenses.
Thought about that, last year, over a year and a half ago.
Mm-hmm. Okay.
Now I want y'all to remember this, because this is something I had to learn too. When they put their foot on your neck, they ain't finna take it off. So if you ever put your foot on their neck and you get a chance to put your foot on their neck, don't never take it off. Don't ever take it off. If you got, because you see what happens. When they get their foot on your neck, they ain't taking it off. Matter of fact, they punish you for being soft. When you start punishing and weakening up, they start punishing you for that. I'm telling you, if you got a lawsuit on them or something like that, and you finna get a big payout, don't take your foot off their neck. Break that motherfucker. Because that's what they're gonna do to you. That's what they're gonna do to you.
Yeah, I just want to resolve this. Whatever I owe for those offenses, I'm willing to pay, and it'll be done with this situation. I truthfully don't think it's your, mission to put people in jail that have not harmed anybody or committed any offense against, any actual live human being. I'm only guilty of speaking out of turn. And, I should have handled this differently. I can see that now, but I really just want to get this whole situation rectified, and whatever the charges are that I need to pay, I'm willing to do that, and I'll put this to rest.
All right, I'll let them speak. Next pretrial date is September 22nd.
Yeah,
Well,
based on the statements.
With that being said, I don't think, based on everything that has happened, our history, the claim in federal court that I have against you, Michigan judicial tenure complaints that I have against you, I think you have a duty to recuse yourself from any of my cases.
I haven't been privy to any judicial tenure complaint. My first duty is a duty to sit, and I feel that I
put it in your mailbox.
Okay, well, all right. Well, the Judicial Tenure Commission will have to come, and I'll have to respond to them accordingly if they present something to me.
Yeah, okay.
All right. Have a great day, sir. Next court date, 9/22. You're still expected to turn yourself into the Wayne County Jail.
Well, Your Honor, I would ask one final argument. I understand that he may have indicated he did not want an attorney to represent him. Jail time is a very harsh penalty. And I know that the court didn't just immediately come to that decision. I would ask if the court would consider some of the things that were stated on the record in terms of he now has a better understanding. He is remorseful of how things played out. And I would ask if the court would issue a monetary fine for the contempt rather than jail. If the court would, please.
And he's got a proceeding in federal court against him. So where is it, you know, where is this,
I'm simply trying to
But again,
protect.
Your Honor,
my
Your
life.
Honor, Mr.
Right,
Lockhart,
hang on,
on behalf
as a-
of Mr. Lockhart, stop.
It does all the time.
What I'm saying, the court has to understand the fact that a lot of these things came into play before today. So if in fact there was something filed, it was before today, before having a better understanding of how the process works, how to conduct oneself in court, and that one is held to the same standards as an attorney. I would ask if the court would consider converting that jail term into a monetary fine.
Now there's a case called Haynes versus Kerner, I believe. Haynes versus Kerner. Let me see if it states what, because you know how they say that you're held to the same standards as an attorney. Let me pull this case up real quick. I think it's Haynes versus Kerner. Let me see real quick. I know somebody had a pleading. People would put this in their pleading, and it is what is it? Let's see if I can pull it up real quick. Man, where is it at? Hold on, y'all. I'm gonna pull it up. Oh yeah, here we go, right here. All right, yeah. I want to show y'all this real quick. SBC University. This for all these documents free on my website too. Y'all ain't got to join my website to get these documents. They got a memorandum of law. Where is that at? Let's see. And it's a long memorandum of law too. This demand for abatement. Notice that this is a demand for an abatement. It is not a motion. It's a demand. You demand your rights. There's it right here. It says, now comes the accused by his own authority, appearing specially and not generally or voluntarily, so as not to confuse the court, and challenges the jurisdiction of this court. Being under threat of arrest if failed to appear, at no time does the accused submit to the jurisdiction and venue of the above entitled court, and at no time waiving any rights whatsoever, knowingly or unknowingly. Accused asks the court to take judicial notice of the fact that he is without counsel, is not schooled in law and legal procedures, and is not licensed to practice law. Therefore, his pleadings must be read and construed liberally. See Haynes versus Kerner. Further, accused believes that this court has a responsibility and legal duty to protect any and all of the accused's constitutional and statutory rights. And that's a nice little intro, that you can use sometimes in your pleadings, and it would help you to read that case also. Because you are supposed to be held to a certain standard if you're going to represent yourself, and whether it's in your proper person or not. You do need to familiarize yourself with the procedures, because 90% of the time how people are getting beat, they're getting beat procedurally. They're getting beat procedurally. Even all the cases that I read where it talks about, this is some sovereign citizen bullshit, it really just boils down to something procedural. Failure to state a claim upon which relief can be granted or something like that. So, and I haven't really seen anything, and they keep talking about all those precedents. All of them look and read the same way to me. I ain't seen nothing where they address anything really. They just cite what we believe, and they don't ever address the jurisdiction that they operating under anything. I'd read all that case law. I'm not impressed. I'm not impressed. I'm just not.
This point. At this point.
Your Honor, I only have a federal claim against you as a means to try to keep myself out of jail, right? It's not something that I want to do, you know?
You can take any action. You can take any action under the law that you choose to, sir. I haven't prevented you or even tried to even attempt to prevent you, and I can't prevent you from doing it.
I don't want to do that. I just want to handle this, pay whatever I need to pay, and move on.
So
You know,
again, advocating
I'm not a
on
criminal
behalf
that
of,
needs to be sitting in jail. I'm an upstanding individual. I have a lot of people that depend on me, and I haven't harmed anyone, and I never would.
This is the conundrum that you involve yourself in, and this is why you need to have some coercive tactics on your side. I like what he's saying right here. He put a claim against him in federal court. You can see he kind of toned down a little bit for that, because really some of these issues need to be brought to light. You know what I'm saying? Because the man just asked you, if you would have just answered the question, what jurisdiction you're operating under, we wouldn't be doing with none of this. None of this will we be dealing with. But you don't want to answer it because they have a bond, okay, that's being traded, okay, and they have an accounts receivable that's aging on their books. He's a hearing officer. The accounting that's going on behind the scenes has to be resolved. Y'all better start understanding that. Y'all better understand the accounting aspect of this. That's why he don't want to let it go. They don't never want to let it go. You can be innocent. They ain't got no witnesses or nothing. They still want to let it go. They'll be bringing you to court 10, 15, 20 times. Don't want to drop the case. You better start finding out why. And it's not what you think.
understood. Thank you for that allocation. But on behalf of, defense would now move to ask if the court would allow a hearing on the contempt proceedings.
That hearing has sailed. He has been gone. He has 30 days for the hearing. Procedurally, that has sailed a long time ago.
So he already had a hearing on it?
No, we asked him, offered a hearing on that. We offered him an attorney on that before we entered into found him in contempt. We offered him to speak with the lawyer on that day. He chose not to. It's been over, I would say, quite frankly, a year at least. The motion he was going to file a motion by 5/27/2022. It's been a long time. Those ships have sailed.
But Your Honor, arguably he didn't have the assistance of counsel. So I would ask, did we go through all of the steps for him to waive his right to counsel in that type of proceeding?
Well, you can go back and look at the transcript. If he wants some representation now, he can either have a court-appointed a lawyer, or he can hire a lawyer on his own. But at this juncture, I'm not inclined. You know, I get people tell me I'm too lenient, and I'm a defense judge, and I try to be fair to everybody that comes through here. I gave Mr. Lockhart, and I'm giving Mr. Lockhart now over a half hour when other people only get 5 minutes to speak. I gave him ample time today and back when he came in court the last time. And you say that he's changed, but he came into court today spewing the same stuff that he started out before he talked to you that he did when he was there. I read those motions that he filed, which was in the court's eyes had no basis in law whatsoever. None. never seen those legal theories that he's purporting. I don't know if you, well, let me strike that. I've seen those legal theories that he's purported, but I've never seen those in the rules of court rules. I've never seen that in any.
What does that have to do with anything? We don't. This is a constitutional question. All right, it's not in any of those things. He ain't never seen it because don't nobody come in there with a constitutional defense. I want to know the nature of the action, man. That's all it is. What you mean legal theories? All right, it's right there in the Constitution. What is the nature of the action? We're talking about the Sixth Amendment.
Of the law books that I've ever read. So I told him this back then, that he needs to go get the rules. I gave him an opportunity to read the rules of procedure. He refused everything. Now, is the transcript of it, you can order the transcript. He can hire his own lawyer, and he'll get whatever kind of hearing that he will get. I'm not going to recuse myself from the case.
Understood, Your Honor.
Okay,
I have nothing further.
very well. Next court date, September 22nd, 2023, will be a pretrial. Have a very good day, sir. And again, your order to turn yourself into the Wayne County Jail.
Okay.
Have a great day.
Okay, I'm gonna get on the internet and see if I can find what happened with this case. I'm trying to get this other case. I thought I had it downloaded already. Is that it? Dang, that counselor. Let me see how long it's gonna take this to download. Now I'm gonna keep talking. I'll see if I can cue this up. This other one, this other case. Might take a little time to download this. I'm gonna have to do it tomorrow because I wanted to show y'all another case. Guy used the same defense and he win. And I wanted to show y'all because somebody, well, show me a case where somebody win. Well, we got one. We got one where somebody, the case got dismissed. It's on Instagram. Brother put it on. Let me see if I can put the link. I'm gonna put the link in the chat. It's on Instagram. If y'all got Instagram, I'm gonna put the this is brother on Instagram. And let me see if I get the link and put it in the chat. This is an Instagram link, so you'll need to be signed into Instagram to look at it. There's the case right there. I want y'all to watch that case. Let me see if it pull up. Yeah, it pull right up. All right, so yeah, you watch that case right there. There's the link to it. Let me see if I can, I haven't even seen if this software can do that. I might not have to even download it. Let me see, can I go to the, yeah. Let me see if I can, might be able to just pull it up like this right here. Hold on for a second. Hold on a quick second. Yeah, I might be able to play it. Hold on. Let me see if I can play it. Post. All right, and then let me see if I can. capture system audio. Okay, let's see if I can play this and if it come through if it come through.
If you're making
Oops, shoot, sorry. I'm sorry about that, y'all. I was just showing y'all my mic was muted. I was showing y'all that that UCC connection, that right there. All right, that is what I want y'all to watch. I want y'all to watch that right there. Watch the UCC connection, that audio book. Watch that, and then think about this case that you just watched. The link that I put in the description, go over to Instagram. You know, join my Instagram. Follow me on Instagram. I post some good stuff on Instagram. My Instagram is Yusef _ L _ 19. Let me put all my stuff on the screen. There's my Instagram right there. There's my Instagram. That's my Cash App. All of that. So I appreciate it. It's been a nice Sunday. It's 12 o'clock at night. Dang, how long was I on? Dang. It was 3 hours. 3 hours. Y'all rode with me 3 hours. This must have been a good ass live stream. Y'all rode with me 3 hours. I must be doing something right. All right, y'all. I know the audio was lost, but it's back. All right, y'all. Peace to the gods. I'll see y'all tomorrow. I'll be back on tomorrow. We're going to go at it again with some more reviews. Is this some crazy stuff? Is it just some sovereign citizen stuff? Is there any basis in law, in fact, for challenging jurisdiction? Do you have a right to ask the nature of the action? You know, why won't they tell you the nature of the action? What's going on? You know, they say that's crazy. This is not admiralty. Well, we know that. Y'all don't call it admiralty. We know that. We know that's what Howard Freeman is going to tell you in that video, that they don't call it that. They call it a statutory jurisdiction. That is the name that they have selected to call it in place of an admiralty jurisdiction. They say statutory jurisdiction. I feel like the attorney did a good job coming to bat for him. She really tried. That attorney put in an effort. She really did. Props to the attorney. Anyway. Peace to the gods. I'm out. I'll see y'all tomorrow. I'm out. Peace.